There's nothing here more to hear.
Lordship.
So
Lordship has heard
that thing has to go.
up to that
97.
97 property.
And the segregate. Put it as chief.
Lordship.
Hearing the
Highly open.
you give me that Delhi High Court judgment. Huh?
Yes.
The reference which you have written.
Yep. Up.
Furthermore to promotion.
Yeah, please. Passport meet up for time being Lordship.
Why?
Mr. Isman Kamulism leg.
1020 matter promotion.
Yes, Lordship.
Yes.
Lordship, already bank has
Oh, yeah, passed by surface. Consider the proposal of the bidder. You have to pay the share of the what happened? They came order.
No, Lordship.
Then what happened?
Lordship, in the till as on today we have paid 7,58,300.
You have filed an appeal under section 17.
Lordship, they have loan was taken by one Ranjan Roy Lordship. We are loan taken another person, Ranjan Roy Lordship.
Understood. You were the guarantor?
Yeah, no, Lordship. I am the he seated us petitioners. He sell the mortgage property. So put some commercial space, Lordship, in the building. That building and property was mortgaged. Assam Government Vikas Bridge. Thereafter he sell us. We sold the property after taking due permission of the administration, Lordship. After purchasing, thereafter same was mutated in our name, Lordship. Then thereafter we came to know that. After we have lodged an FIR against Sri Ranjan Roy, and we are approached the bank for final settlement, and then they have
Understood. But madam, why you are not going under section 17? You've been there under section 17 before the DRT. How can I help you? Tell me. Get your senior.
yes, yes.
Sir, what?
For the bank, actually previous council already expired. So today I got the brief.
Sometime and get your instruction what has happened at the bank.
Yes.
Proper. What date?
Lordship, there was a direction to take step upon respondent number 7, Lordship. I have taken step yesterday.
Sir,
N.
name?
N. Pathak.
N?
Pathak.
And Pathak will learn after the period. We have the case already taken. Oh no, 7 or 6.
7, Lordship. 6 is appeared. 6 has entered appearance.
Well,
Yesterday.
take it up the above. But
Let's go.
another 4 for admission. And has appeared on behalf of the petitioner as well as the that part. So that's it. It's good.
Lordship, I'm from accountant.
Yes.
I'm from accountant.
Huh?
Accountant.
5 to 7. Order. This court has directed an affidavit to be filed by the Eastern Register,
Yes, my lord.
but
That
have
was
they
the-
filed it? Mr. I
Right.
number 1,
Yes, my lord. IP high speed.
but you don't have your certificate is not on that
On
thing.
before my lord submit
Your certificate is 29-1.
Yes.
29-1 or 29-10 or something.
2019.
Huh?
2019, man.
Yeah. The certificate is no encumbrance certificate.
But my lord, I applied for my lord. It was not given.
Understood, but then also the NIT required that certificate.
I submitted the my lord application copy.
Understood,
With
but
NIT.
when that 46, but the question arises out here as to whether what is the requirement of a non-encumbrance certificate? Because that's the mandate of there. Yes. Let's see that the factor is where is the NIT?
NIT my lord, it was fine. Please, my lord.
Bakizai clearance certificate from the Deputy Commissioner of the concern.
Yes.
Now let us see what is the Bakizai clearance certificate. What's that? Where is Mr. KK Mohanto? Not to be seen. Hello. Let us dismiss this repetition. Your repetition goes out there because you are not there. Other two repetitions can dismiss for default. Hey, Bengal Public Recovery Act.
Page 70, my lord, that is not practical.
No. Bakizai certificate is given under what?
Bakizai certificate is my lord for the purpose. If any Bakizai case is pending against the,
Oh.
but that's all.
Is to certify that if there are any Bakizai proceedings is pending.
Pending.
Now, if there is no Bakizai proceeding pending, merely if you have a particular amount to be paid,
Right.
that would not come within the ambit and
Before-
you cannot cancel it. Hello. Your case too, you don't have leg to stand. As regards the other two, counsel is not represented. It is compacted. The record reveals that Mr. Depaya appears on top of the
Item number 7.
what's the number?
Item number 7, my lord. 2749 of 2021.
Appears on behalf of the Deputy of 2021. In the said petition, admittedly, the petitioner did not submit the non-encumbrance certificate, the Pakistan certificate on the last date of submission of the document. Last date for submission of the paper. Under such circumstance, the NIT which was the bid which was submitted by petition was not complete. Be that as it may, the counsels appearing on behalf of the petitioners, that is deputation number 4205 of the 2020 and deputation 1 of the 2021, are not represented. Neither, apart from that, the standing counsel appearing on behalf of the Corporation Department as well as the Fishery Department are not represented. So, under such circumstances, it appears that the petitioner deputy number 1891 of 2021 and deputy number 4205 of 2021 are not interested in pursuing their petition according to
At 2 p.m. The partner at 2 p.m. picked up
2 p.m.
yes, sir. Item 5, sir.
p.m.
5 and 6, sir.
according to Really, otherwise
Please.
Item number 8.
But in this case, yesterday there are respondent number T 4, 5, and 6 filed an affidavit. I may be allowed
item number 8.
3 weeks time may be granted to file reply.
If they file them.
Yesterday.
Oh, that part.
Lord.
What do they say?
So far, their allegation, Lordship, our application are not considered.
You
And-
file the
No, sir, 2nd of February. Actually, it also have filed 30 of January. Unfortunately, I have filed 2nd of February.
you are responsible.
Respondent number.
3,
Respondent
4,
number
5.
3, 4, 5, and 6. sir.
Yes, what is your affidavit? Not
Yeah,
on the court.
In point of time, Lordship, there was no any effective rules and guidelines to allotment the housing board status. That
So what did you follow?
at that time it was decided by the
As a
board.
board
A
member, you
committee,
like you give.
a committee was constituted at that moment. Lordship, they had decided to allotment the flats. Lordship.
Decided up. Is the public of that is the public of so can that be given that I like his face, I don't like his face? That be given or he is related to me, he is not related. That be given.
At that moment of time, Lordship,
That
out
was
of
permitted.
9,000 applicants were received.
So once you pass
Out
that,
of 9,000
you
already.
should have some yardstick. If you didn't have any yardstick, then the allotment has to go. And they filed the petition at the relevant point of time. When did you file?
was filed
You filed
in
in 2015,
2015.
didn't it?
2015.
When was the allotment made?
It was 2013, Lord.
By the delay of years?
So subsequently, I came to know it. At that,
What is actually
It was a direction was given by this Honorable High Court to frame the guideline for allotment of the housing board flat.
Yeah.
Then we have comply that guideline.
But
And-
anyway, this settlement if it is done in this manner. That has to go. Yes, you have a copy of the affidavit,
yes, sir.
but you need time for filing it. Allow your what is there- who was the final authority? Board of Directors.
Board of Directors.
And who is this respond number 7? The commissioner. Respond number 7 was the commissioner.
Yes,
Commission.
Lordship. Respondent number 5 and 7 are
And the
tempered.
board of directors consisted of the commissioner.
It is called
Yes or no? Sir, you're not prepared.
Today, Lordship.
Huh?
I'm not prepared.
Why? When the court is in your trying to help you out, but you're not prepared. How many years of practice you have? Isn't it the state of affairs? How many years?
15 years. 15 years.
15 years and you are not prepared to do the matter, and when the matter I have fixed it on a particular date. Does it look nice? You knew the matter was fixed today.
Yes.
You don't have any urgency for your clients.
In the second half, Lord.
The learned counsel appearing on behalf of the petitioner submits that he is not ready to argue the matter as he is not prepared. He further submits that an affidavit in opposition has been filed by respondent number 356 and he may be permitted to file a reply. Court fixes the matter date on 11th of March 2024. Affidavit filed by 4th of March 2024. Hey, that is sorry. Yes, what's your name?
Yes, Alam.
S.
Alam, Lord.
Ada. Come to the hook. Donga kita pa. Not
Mark
prepared.
9,
my lord, with the scheme I'm under which my lord the petitioner applied for capital investment subsidy, my lord. My lord, as per this, my lord, clause 9, I applied for LOI, but LOI is not a compulsory, my lord. The lawsuit come to my lord, chapter 1, clause 9.
What are you asking for?
My lord,
Your prayer.
I will not have
Asking the
rejected.
issue of the hearing body.
Yes.
That you I think principal executive Yes. Yes, what's your
My lord, petitioner applied, my lord, for issuance of the LOI. My lord, LOI, my
this
lord,
LOI?
you can also find at page 20. That is my application. I've given all the details. Then, my lord, they have issued a letter, page 21. They stated it,
LOI for what?
LOI for establishment of a cold storage unit.
Okay. Letter of intent.
Yes. So now, page 21, my lord, they have treated, my lord, they issued this letter saying that the disease which happens to letter number 3317, whereby you submitted project proposal for expansion of cold storage unit, but it is not for expansion, my lord, it is establishment. There are two, my lord, things, my lord,
Setting up.
setting up.
And
And scheme, and as per the scheme guideline, preliminary examine the following project, the following documents, information are still pending. My lord, these are for expansion. I have applied for, my lord, establishment, my lord.
but don't you require NOC from State Pollution Board?
For
setting up.
expansion, my lord, that is,
Whatever may be.
no, because earlier, my lord, they have to take, because pollution control board, my lord, will give the, when the establishment is there.
Now you are challenging this document.
But this document is wrong, my lord, because they have treated this expansion.
See the impugn order, what has happened?
No, yes, ma'am. Now, impugn order, your loss will find, my lord. That page 37. This contract confirm that Department of Agriculture plans to government replace the letter of intent system with principal approval system with effect from 1/4/17. The promoters who have not obtained LOI before 1/4/17, but banks have sanctioned term loan for agriculture project NHB to public notice on the website that the promoters who have availed term loan bank of their project have not opted for LOI from NHB who are requested to get registered their proposal online with NHB during the period from 1/9/17. Only those projects are eligible for issuance of LOI of IPA under the scheme of NHB in which term loan has been sanctioned after 1/4/17. So it further informed that the result of documents provided by you, Punjab National Bank, Guwahati sanctioned term loan of 600 lakh in the instant case on 9/17 as per able records. The promoters have neither obtained LOI from NHB nor get registered their project online with NHB during the validity of 19/17 to 39/17. The matter was placed before the competent authority of the board and to the decided the NHB has already given ample opportunity to such promoters for online registration with NHB who have not opted for LOI from NHB. Promoters of the Gram Guwahati Assam failed to register their proposal with NHB during the validity period and system has already been placed by IPA system. Only those projects are eligible for issuance of IPA under the scheme to which the term loan has been sanctioned after 1/4/20. Hence, the same may be returned in original return. Well, this is the, well, here your loss is fine.
So
I
when
applied-
did you apply for the term loan?
I have applied for, well, yes, my term loan has been sanctioned, my lord, on 9/3/17. Then I applied for LOI under the old scheme, my lord. That scheme I have given, my lord, to your lord.
This is of 2015.
2014.
Then?
In this scheme, if your losses see, my lord, the LOI is not a compulsory, my lord, if your losses come to chapter 1.
Okay.
Chapter 1, my lord, the clause number 9.
Page
Page is 21, my lord. Bottom.
Yes.
My lord, clause 9 is your losses see. Letter of intent will be voluntary for promoter and would be issued only at the request of the promoter. This will not be required for claim of subsidy.
you are asking for subsidy.
I am asking for subsidy,
What subsidy?
my lord, capital investment subsidy. So they say that you have not obtained LOI, but the LOI has been, my lord, they have not issued the LOI, wrongly treating my application as a
But this application is only for request for issuance of
LOI.
principal approval to so and so for LOI.
LOI, my lord. First on the
So
LOI.
how does this have any relation with that particular document? Whether you are now saying that for getting the subsidy, you don't require an LOI,
LOI not necessary.
not necessary.
Not
Then
necessary.
how is this relevant, this document of the 2nd of March 2018?
Mm.
That only says about not giving you the LOI because you did not apply during the
No,
period.
They have said, my lord, that you have not obtained LOI, so you are not getting the
Where is it?
my lord, that is there. They have released it, my lord, return it.
So it does not say anything that you are not entitled to the subsidy.
My lord, actually, that is that, my lord.
What virtually? Why should we go into the virtually business
My lord.
when it is physically
No,
possible?
now your lordship see, my lord, the next page also, page 38. Page 38, my lord, second paragraph. In this context, the undersigned is directed to say that on perusal of submitted documents information available on NHB website, the promoter see come cold storage has neither got data from the National Executive Board nor got online register of NHB up to 3917 for claim of subsidy without availing advice. In view of the above, the Company Board has considered the request and decided that the proposed contract for the unified is not found to be eligible after consideration of all facts. This is
So your case is that without the LOI also,
Yes.
you can claim subsidy,
Correct.
which have not been done.
not been done.
Now, is that a part of your writ petition? A stand taken in the writ petition? Because if you have taken, you would have brought on record this document.
My lord, actually, I am
No, again, don't go by virtually. Let us go physical.
my lord.
Yes.
No.
Virtually, it's not.
No, we are
Obviously, it is
challenging.
not there.
We are challenging those
You have,
orders, my lord.
you must have got hold of it recently.
No, not recently, my lord.
Then if we have got it, then on the ground of not placing this as material, shouldn't we dismiss the writ petition?
My lord, my lord, my
Because
lord,
they
your
have no answer. They are not. How will they answer to that?
if your lordship
That is
see,
not
my lord,
your case at all. How you have developed your case in this manner? Don't you require to file it by way of an additional affidavit? Yes, what do you say, Mr. Shah?
my lord,
Your lordship, what has happened is that pursuant to the rejection under the old scheme, that was rejected on 3/4/17, your lordship has seen, page 21. There was a change in the, where they say that with effect from 1/4/17, they have given a specified period of when they have online application will be accepted.
So this scheme is not there.
This scheme is not there. And your lordship, what happened is that pursuant to the new scheme, they have applied on, so they waived their right under the old scheme. They have applied under the new scheme, and this rejection is under the new scheme. And this new scheme specifically says, if your lordship says, page 23 of the writ petition.
Hmm.
This is the public notice. May I read your lord? National Horticulture Board has introduced in principle approval. So they have shifted from letter of intent to in principle approval with effect from 1st April 2017 for its credit link based N subsidiary scheme on commercial horticulture and cold storage. Online application in prescribed format will be accepted only for new projects where bank has taken term loan on or after 1/4/17. His loan was in the month of March. Yes. Online application will be accepted between 1/9/17 to 39/17. So he has not even applied between this period. His application is under 24/1/18. So under the new scheme also he has applied belatedly. However, considering the limited budget, this part is not important. If they receive sufficient number of applications, they may stop before.
So this scheme, the Sahavala is being has
It's
no
no relevant. And your lordship now, however, considering the people who had got the term loan before 1/4, they have given a window also that your lordship will find in page 23, 22, 23.
22.
No, yes, your lord, 22. Board is receiving subsidiary claims of credit link projects under commercial horticulture scheme and coastal scheme for cases where term loan has been sanctioned on or before 34/16. An
That
applicant
is
has
also
not
not applicable.
not applicable. However, they have given a window to register themselves between 39/17. So if they don't register, either they should have a letter of intent which was rejected to them, or they should get it registered on the basis of the term loan given before, which they have not done.
No, no. If they apply as per the old scheme,
That application was rejected on 3/4/17,
where?
page 21. And now they have not even challenged this rejection in the present report.
So that application was
Rejected.
the matter and
And
so that therefore that scheme is already over.
yes,
Now comes the new scheme. They applied for the new scheme,
and new scheme should be applied between 19 to 39/17.
which they have not.
No,
And,
they have in
and as per the new scheme, you require the principal in
principle approval. But those who have, but as a for bona fide reason, those who have got a term loan before April, but could not
But
get,
that is only till 34
Yes.
2006.
yes, they should have got themselves registered, which they did. So they were negligent over their rights, and now they are trying to claim subsidiary as a matter of right. But they should fulfill the condition to accept the to receive subsidiary, which cannot be distributed like this. There is certain norm. So in that manner, they don't have, their legal right has not been infringed, and they have not challenged the first rejection. They have said that, so they have stopped from raising, challenging this now. Or they have waived the right because they have applied subsequently, knowing the law. Your lordship will see the first rejection, page 38, or on the subsequent application. In para 8 of the requisition, they specifically say they have applied on 24/188. So that is a second application under the new. So they have waived their right under the whole. And the rejection letter, your lordship, is page 38, first rejection under the new scheme,
Which one?
May 2, 2018. So in fact, they have challenged this.
Page?
Page 30 is not numbered here, page 38 as per the index.
First purpose to come.
No, that is the 2nd May 2018 is the rejection.
Where is the scheme? Where is the scheme as per the new act? New scheme after 1/4.
That the notification is page 23.
That is only a notice.
Notification. Notice.
But you must be having a scheme
Yes, that is not.
guideline.
Yes.
Right.
that is not connected. If it were. But the ground of rejection on the 2nd May. First August is the second May is the first rejection. $37.
So they did not submit it on 2007.
Yes. If they have got it registered, even with the previous term loan, they could have again applied under the new scheme.
Next that art is similar to page 23 with 2.
Part 2. Yes, Your Honor. Yes. Same.
So your submission is first his application was rejected earlier. Not rejected, it was returned.
Return. Incomplete.
Incomplete
Complete
on
form.
whatever may be, it was returned. So that matter ends out there for the
Yes.
earlier form. Now he did not do anything. He thereafter applied for a fresh.
Yes.
When did he apply for the
It's 24/1/2018, para 8 of the writ petition.
he
24/1. Page 9, para 8,
24/1?
2018.
He applied.
Yes.
Although he ought to have applied within the period from 1/9/2017 to 13.
Yes.
He did not apply.
He did not.
And apart from that, if he had also applied, he could not get because his term loan was given on 9/3/2017.
Yes.
Now he is now challenging.
Now challenge
Now
is
the question is as to whether in principle approval is required for the purpose of granting the subsidy.
from the public notice, it is separate, but if your lordship requires the guideline, then I may.
Because that's the reason why. The guideline,
Right.
the new guideline,
That would be your lordship. I'll have to take that up.
but
But
he may have, but we have not paid them. Why did I say the inevitable?
Yes, and that is not his even contention in the writ. He is now trying to claim under the previous application.
See that I gave the book.
But-
both that you
Yes, but this, once he has knowingly the change in law, the public notices and everything, and he has knowingly applied under the new scheme, he has waived his right under the old. Then he knows that he has
without telling
without challenge. He has waived his right. Now he's stopped from saying that I have to apply, I have to get under the old scheme.
the
Yes.
Yes, but
My lord, I am submitting, my lord. Under the new scheme, if your lordship see page 23, my lord. That way, my lord, term loan is to be sanctioned on or after 1/4/17. But my term loan is sanctioned earlier, my lord. Prior to that. And moreover,
now people apply.
my lord, I applied in the old scheme. New scheme also, my lord, I wrongly, my lord, submitted that because I cannot apply under the new scheme. new scheme because my term loan is sanctioned after 1/4/17 only, I can apply.
So where is the question of telling the issue?
No, impugn order, my lord, I'm submitting that.
You are not clarifying that the earlier
LOI, my lord, is not required, my lord, for that purpose, because I'm challenging this order, my lord, if you also see that page 38, my lord. Page
that
30,
is not your prayer out there. If it's not that you ask for subsidy. You say your relief is either set aside that order.
Yes.
Second, either give me LOI this way or that way,
my lord,
or the in principle. That is your subject matter, the entire thing. So where is the question of subsidy?
subsidy, my lord, because LOI is not essential.
Now you are saying,
Right.
but how saying that LOI is necessary? But
Yes.
the fact that you have already proposed an audit process for me,
Well, earlier process, well, if you also see that they have returned it by treating it as a expansion unit. That is their mistake, my lord.
you have to tell it that.
Hello.
If you tell it, they, you tell it.
My lord, although not directly, my lord, now
And it's not your case also that your subsidy you have not been granted in spite of it was not a LOI. Have you made any statement out here that without an LOI the subsidy should be granted? Or you did your prayer out here that the directive be issued to grant the prayer?
my lord, my question is, my lord, since of the LOI as per the earlier scheme, and diagnosis on this, anyway, my lord, your losses may, my lord, may not go the prayer only, my lord, because in when
I have
my lord,
them and it's the judgment of the stated that it's there. You have it, you know it's offered, you know,
maybe I have to amend the, my lord,
amend ethics.
my lord. On the face of it, it is their mistake, my lord, that keeping it in expansion.
That mistake let it be in 2018. Mistake has now let us let me see. The instant repetition has been filed by the seeking a writ in the nature of Andaman. Seeking a direction, seeking a writ for setting aside and quashing the letter bearing number NHP of the IPA dash P Shyam Code Story of the 2018-19 dated 5/2018, as well as the letter bearing number NHD of the IPA of the 80 AAS of the OCS of the 0000015 of the 2018-19 dated 1/8/2018, and further a direction and further a declaration that the petitioner is entitled to either in in principle approval bracket IPA for construction of the cold storage under NHB new scheme inverted comma capital investment subsidy scheme for construction of the expansion of the modernization of the cold storage and storage for horticulture purposes inverted comma close, or in the letter of intent bracket LOI as per the earlier scheme as on 30/3/2017. And further seeking a direction that the in-principle approval as per the new scheme or the letter of intent as per the old scheme be issued to the petitioner. The facts involved in the instant case is that the petitioner, which is the partnership firm, coming to learn about various schemes of the National Horticulture Board, NHB, decided to open a cold storage with storage capacity of 11,000 metric tons for storage of vegetables and fruit at Polasbury Road, village Korapara under Moza Sayoni of Polasbury Revenue Circle. In that regard, the petitioner firm approached the respondent authority and an operational guideline was issued to the petitioner firm for the project. It is claimed by the petitioner that the petitioner firm changed its financial position and applied for term loan from the Punjab National Bank, Pennsylvania branch. The term loan was sanctioned on 9/3/2017 for an amount of rupees 600 lakhs. It is further stated that the petitioner thereupon filed an application for obtaining the letter of intent (LOI) as per the scheme on 30/3/2017. Along with the said application, the petitioner submitted various documents. The said application, however, was returned on 3/4/2017, that is within a period of 4 days. So on that date, sir, was returned on 3/4/2017, stating inter alia that various documents were not placed on record. Which it is not known as to whether the petitioner thereupon pursued on the basis of the said application filed on 30/3/2017. But one aspect is clear from a perusal of paragraph number 8 of the writ petition, that the petitioner applied afresh on 24/1/2018 Thereby, which clearly goes to show that the petitioner had foregone the earlier application process. It is, however, relevant now to take note of that on 15th of August 2017, a public notice was issued by the National Horticulture Board wherein it was mentioned that the said board had introduced in principle approval bracket IPA into I2 capital P2 capital A. IPA bracket system with effect from 1st of April 2017 for the credit linked back ended subsidy scheme on commercial horticulture and cold storage. It was also mentioned that the online application in the prescribed format would be accepted only for new projects where the bank had sanctioned term loan on or after 1/4/2017. Further to that, it was also clearly mentioned that the online application would be accepted between 1/9/2017 to 30/9/2017. It is also relevant to take note of that the petitioner, no, take note, the operational guidelines for the capital investment subsidy scheme for construction, public expansion, public modernization of cold storage and storages for horticulture. In relation to the new scheme, the same is a part of Annexure Roman 3 to the petition. In terms with the said operational guidelines, it was mentioned that from 1/4/2017, in principle approval is mandatory for availing financial assistance under the credit linked back end subsidy scheme of NHB. Further to that, it was also mentioned that it was mandatory to submit the online IPA application in the prescribed format available on the board's website. And with the online application, it was necessary to upload the copy of the detailed term loan sanction letter of the bank, public FI, bracket in principle sanction letter, oblique bank consent letter not accepted, bracket close, issued on or after 1/4/2017 for a new project, oblique activity, and a copy of the DD as proof of payment of the application fee in cases of payment not made online. Therefore, from a perusal of Annexure Roman 3 to the writ petition, it is clear that to avail under the new scheme, the term loan, the sanctioned term loan has to be on or after 1/4/2017 and at the same as also has to be done within the period from 1/9/2017 to 13/9/2017. It is also clearly mandated that in order to avail the credit link back-ended subsidy, the in principle approval is mandatory. Be it as it may, next. The petitioner who applied on 24/1/2018 under the new scheme, its application was rejected by the communication dated 2/5/2018 on the grounds that the petitioner sanctioned loan, term loan was sanctioned prior to 1/4/2017, and secondly, on the ground that the petitioner did not apply within the period from 1/9/2017 to 13/9/2017. It was also mentioned, also, this communication dated 2/5/2018 has been put to challenge in the instant proceedings. Further to that, on 1st of August 2018, the Deputy Director of the National Horticulture Board also informed the Chief Manager of the Punjab National Bank that the petitioner was not entitled to the subsidy on account of, on the ground that the petitioner did not get was not issued a letter of intent under the earlier scheme, nor the petitioner was issued an in principle approval as per the new scheme. What have not received the letter of intent, neither it got the letter of intent from the National Horticulture Board, nor got online registered with NHB up to 13/9/2017 for claim of direct subsidy without availing LOI from NHB. The communication dated 1/8/2018 informing the manager that the petitioner was not entitled to the subsidy on the ground that the promoters of the petition neither got the letter of intent from the National Horticulture Board nor got online registered with NHB up to 13/9/2017 for claim of direct subsidy without availing LOI from NHB. This communication has also been impugned in the instant petition. Before further proceeding, this court finds it very pertinent to take note of another public notice which was issued on 4/9/2017, which has relevance to the impugned communication dated 1/8/2017. The said public notice dated 4/9/2017 was issued, thereby giving an additional opportunity to those units who had availed term loan prior to, on or before 30/4/2016 and had not obtained the letter of intent from the NHB. Under such circumstances, those applicants have been given a window to register themselves with the NHB on or before 30/9/2017 and fulfill all the eligibility criteria of the operational guidelines of the respective scheme. It is also admitted that the petitioner did not avail such opportunity as was granted by the public notice dated 4/9/2017. In the backdrop, be it as it may, the petitioner being aggrieved by the impugned communications dated 2/5/2018 as well as 1/8/2018 has approached this court seeking the relief as above mentioned. Next. The instant petition was filed on 12/10/2018 and this court by an order dated 2/11/2018 had issued notice. The record reveals that an affidavit in opposition has been filed by the respondent numbers 2 to 5. In the said affidavit in opposition, various preliminary objections were taken as regards the maintainability of the writ petition. Apart from that, it was mentioned that the National Horticulture Board was set up by the Government of India as an autonomous body with a mandate to promote the integrated development of horticulture and to help in coordinating, simultaneously stimulating and sustaining the production and processing of fruits and vegetables, and also to establish a sound infrastructure therefore, with special emphasis on post-harvest management and cold chain to reduce losses. For accomplishment of such objective, the National Horticulture Board provides assistance by way of subsidy under various schemes prescribed for the purpose to facilitate the implementation of cold storage projects which fulfill the prescribed criteria of the operational guidelines of the scheme, one of such scheme being inverted comma capital investment subsidy scheme for construction expansion modernization of cold storage storage of horticulture produce. It has also been mentioned that the said scheme for grant of capital investment subsidy is applicable for setting up of only those cold storage projects for horticulture crops which are implemented as per the scheme guidelines and in conformity with the prescribed technical specifications. It has been mentioned that the petitioner submitted an online application with the respondent number 2 on 24/1/2018 for seeking issuance of in-principle approval for setting up of the cold storage for capacity of 11,000 metric ton under the general category. The hard copy of the said application was received on 5/2/2018 along with the prescribed application fee and enclosing a copy of the term loan sanction letter dated 9/3/2017 issued by the financing bank sanctioning a term loan of rupees 600 lakhs for the petitioner's cold storage project with project cost of rupees 910 lakhs for creation of 11,000 metric ton capacity. It was also mentioned that as per the documents which were submitted by the petitioner, the lending bank disbursed the term loan during the period from 26/5/2017 to 7/2/2018. However, as per the operational scheme guidelines, the National Horticulture Board could consider only those proposals where the term loan had been sanctioned on or after 1/4/2017. However, as the term loan was sanctioned on 9/3/2017 and the same was disbursed to the petitioner during the period from 26/5/2017 to 7/2/2018 and therefore was not covered in terms with the scheme guidelines of the respondent National Horticulture Board. Further to that, it was also mentioned that the government, by its circular dated 28/3/2017, had changed its policy of issuance of LOI and introduced a new system of issuing in-principle approval, which may only be issued after sanction of the term loan from the financing bank and also after getting technical scrutiny of the project cleared by a technical expert, which was mandatory for consideration of any proposal under scheme number 2 of the National Horticulture Board. It was also mentioned that the National Horticulture Board had issued a public notice on 15/8/2017 informing the general public about submitting of the online application on or within the period from 1/9/2017 to 30/9/2017. However, the petitioner did not apply during that window. In the backdrop of the above pleading, this court have also heard the learned counsels appearing on behalf of the petitioner, on behalf of the respective party. Mr. G. N. Sahavala, the learned senior counsel appearing on behalf of the petitioner, submit that as per the operational guideline, which was prevalent at the time when the petitioner submitted the first application on 30/3/2017. There was no requirement for an LOI for the purpose of getting the subsidy. In that regard, during the course of the hearing, he had placed the operational guideline, which was operation guideline issued by the National Horticulture Board of the during the month of September 2014, which is kept on record and marked with the letter X. It is therefore the submission of the learned counsel appearing on behalf of the petitioner that the petitioner is entitled to the subsidy, taking into account that the petitioner subsidy, taking into account that the petitioner's term loan was issued. The petitioner did not come within the ambit of the new scheme, which was made effective from 1/4/2017, and there was no requirement for the term loan requirement of the letter of intent for the grant of the subsidy in question. In that regard, he made specific reference to clause 9 of chapter 1 of the operational guidelines issued in the month of September 2000. The learned senior counsel further submitted that as the petitioner's term loan was sanctioned on 9/3/2017, irrespective of the petitioner applying as per the new scheme, the petitioner is entitled to the subsidy in terms with the old scheme prevalent when the petitioner submitted his application on 30/3/2017. Anything else? I mean, for contra, Mr. R. Sharma appearing on behalf of the respondent number 2 to 5 submitted that as per the new scheme, there was a requirement of an in-principle approval for getting the benefit of the subsidy. For the purpose of claiming the state in-principle approval, it is required that the bank had sanctioned the term loan on or after 1/4/2017, and the application had to be made between 1/9/2017 to 30/9/2017. Specific reference was made to clause 3 of the operational guidelines for capital investment subsidy scheme. He therefore submitted that as the petitioner admittedly applied on 24/1/2018 and the term loan was sanctioned on 9/3/2017, the petitioner therefore was not entitled to as per the new scheme. The Learned Counsel further submitted that as regards the old scheme, the petitioner, though applied on 30/3/2017, but he did not submit the necessary documents for which his application was returned on 3/4/2017 itself. The petitioner thereupon did not agitate the matter of returning the said application and refunding the amount of rupees 10,000, which was paid, which was the application amount. Rather, the petitioner on 24/1/2018 applied for the new scheme under the new scheme. He therefore submitted that the petitioner, having foregone his right in respect to the earlier scheme and the new scheme being not applicable, the petitioner cannot would not be entitled to any subsidy. Further to that, it is also the submission of the Learned Counsel appearing on behalf of the petition respondent that the petitioner, that a perusal of the relief claimed for, as well as also the writ petition, it would show that the petitioner had only sought for the grant of the in-principle approval or the LOI, but there is no relief sought for as regards the subsidy.
And he has also not registered in terms of 4/9/2017.
The Learned Counsel further submitted that the petitioner even did not take the opportunity in terms with the public notice dated 4/9/2017, thereby granting, whereby the National Horticulture Board had granted an additional opportunity to those persons who did not apply. No, those persons who did not apply as per the old scheme. This court have duly perused the materials on record and have also duly noted the respective submissions of the party. From the materials on record, and the submission made by the Learned Counsel for the petition, it is clear that the order date, the impugned communication dated 2/5/2018, the submission of the Learned Counsel for the petition. It is the opinion of this court that the communication dated 2/5/2018 has been rightly passed and there is no error of law apparent on the face of the record. Inasmuch as the petitioner's term loan was sanctioned on 9/3/2017 and the petitioner did not apply within the window provided, that is, with effect from 1/9/2017 to 30/9/2017. Under such circumstances, The question of interference with the impugned order dated 2/5/2018 does not arise. In the past, this court have also taken note of the impugned order dated, impugned communication dated 1/8/2018, which stipulates that the question of which stipulates that the joint inspection report, the request for the joint inspection report which rejected the request of the joint inspection report on the ground that the petitioner have neither got the letter of intent from the National Horticulture Board nor got online registered with the National Horticulture Board up to 30/9/2017 for claim of direct subsidy without availing LOI from the NHB. Though it is the case of the petitioner that the petitioner applied on 30/3/2017 but the said application is an application for issuance of the LOI. The same is apparent on a reading of the said application itself. The said application, however, was rejected on 3/4/2017 on the ground that various documents were not placed. And was returned. The petitioner did not challenge the said document of rejection of the application for issuance of LOI. The petitioner also did not take steps in pursuance to the public notice dated 4/9/2017. Rather, on 24/1/2018, the petitioner applied as per the new scheme. Under such circumstances, the question of interfering with the decision of the respondent authorities in not issuing the LOI to the petitioner does not arise. Be that as it may, a question duly arises as to whether the petitioner would be entitled to the subsidy claim even without the LOI. Inasmuch as it is the specific submission of the learned counsel for the petitioner that LOI is not mandatory for granting the benefit under the scheme for granting the benefit of the subsidy. This court had duly perused the operational guidelines of 2000 as notified in the month of September 2014. It has two chapters. The first chapter relates to the guidelines for making application for assistance under the Commercial Horticulture Scheme 1 and Cold Storage Scheme 2. The second, chapter number 2 is the guidelines for making subsidy claim and release of subsidy under the Commercial Horticulture Scheme, Scheme 1, and Cold Storage Scheme, Scheme 2 of the National Horticulture Board. Not a single document had been placed which shows that the petitioner applied in terms with Chapter 2, seeking the subsidy. As per the guidelines issued. In that view of the matter, this court, Mr. Sahiwala, did you apply as per Chapter 2 for subsidy? No. This court had also put a specific pointed query upon the learned senior counsel appearing on behalf of the petitioner as to whether the petitioner applied in terms with Chapter 2 of the operational guideline of the issued in the month of September 2014. He submitted that he has no instructions in that regard. So, under such circumstances, it is the opinion of this court that the order dated 1/8/2018 that the communication dated 1/8/2018 cannot be said to be a communication issued in violation to the operational scheme existing at that relevant point of time in terms with the operational guidelines issued, both the earlier scheme as well as the present scheme. And further, there was any error of law apparent on the records. It is also relevant to take note of that the petitioners have also not sought for any relief as regards the subsidy. The presumption that can be drawn as to why such relief has not been sought for, in as much as the petitioner have not filed any such application in terms with Chapter 2 of the operational guidelines as it stood in the month of September 2014. In that view of the matter, the court finds no ground, no merits in the instant writ petition, for which the writ petition stands dismissed.
The operation guideline is not required by officer. I will
Part of
take
it.
marks it is my mind.
I say that to be a part of the judge.
Yes, I oblige.
Yes,
Lordship, in this case, we are third party to that particular loan. What happened in this case, the Ranjan Roy, who was the owner of that particular building, he has taken a loan, and that by suppressing that fact, he has sold the
only to you.
yes to us.
Have you been to the
No, Lordship. Yes, Lord. That is there. Lordship, thereafter,
There
Yeah,
are
well-
limitation act applies to the
yes,
year to what that's the benefit that the period to get.
Yes.
Not decide
because alternative remedy.
whatever that have been done.
there was outstanding approx 11 lakhs. And they approached
Given
the
the
bank.
money, 11 lakhs that they paid.
No,
and
We have paid
what have you
7
done? You told the,
Outstanding.
told the client,
no.
the learning council appearing on behalf of the petitioner submits that in view of the provisions of section 17 of the petition would be well advised to approach the jurisdictional debt recovery tribunal rather than pursue. He therefore submits that the petitioner may be permitted to withdraw the petition without prejudice to his rights and claims to be rights and claims, and the time during the period during which the instant proceedings have been pending be excluded while completing the period of the court have really taken over the submission domain and from a petition of the orders that have been passed, it reveals that the petitioner has been bona fide bona fide pursuing his remedy, but the treated as it may, the dispute involved in the instant proceeding can be decided in the proceedings under section 17 of the Subsidy Act. And as such, this court grants the liberty to closes the instant petition of withdrawal and grants the liberty to the petitioner to approach the jurisdictional debt recovery tribunal by filing appropriate. The petitioner further, but it is also observed that as the petitioner have been bona fide in litigating the instant proceeding since 17/6/2020 till date, the instant proceeding, the period during the period from 17/6/2020 date, they excluded by it also observed that the withdrawal of the instant petition shall not be the restriction in his rights claim respect to his rights over the property in question before the debt recovery tribunal. But it is
Lord, this is a promotional dispute, Lordship.
Huh?
Promotional dispute. The petitioner before
what
Lordship,
issue?
promotional dispute, Lordship.
Promotional.
Lordship is a grade 3 employee under the district judiciary Dhuburi.
And
Lordship, his junior is given promotion, depriving him. The criteria of giving promotion under Assam District Sessions Establishment Rules 1987, Lordship, the merit cum seniority, which has not been
Wait,
followed in this case.
the council. Look, first of all, what happened? A notice inviting paper,
Lordship,
not a whether advertisement must have been. Who are you?
I am a grade 3 employee,
You
Lordship,
are a grade 3 employee.
under the
What is your job?
and
You are a revenue assistant,
no supervisory.
Huh?
As a supervisory assistant.
supervisory. And what are the rules which apply?
The rule is that seniority come merit.
Is for promotion.
Sure.
And what are the rules? First, let us know the mother, then we'll go to the child.
Lordship.
What are the rules? What rules? Service rules.
Oh, Lordship,
Which one?
Assam
District and Sessions Judge Establishment Rules
Where is-
1957.
You have enclosed? Have you enclosed?
Lordship, in my reply, affidavit in reply, page number 47, 47. Lordship.
47? 47 is the minute. I'm not saying that. Where are the rules?
Rules, Lordship, in my affidavit in reply, affidavit in reply. Annexure A,
Yes, tell me.
Lordship, then kindly come to
Thank
page 54. Seniority,
Okay. in reply 2012. Got it. Yes.
Lordship, seniority, page
Assam district and
Assam
Section
District
Judges
and Sessions Judge Establishment
Minister
Servitude, 1987.
Okay, now where do you come within?
Lordship, seniority, page 54,
Yeah,
12.
it is recruitment.
recruitment.
You are the in which category you are? Service shall comprise of the following: solicitor of district. You are not. You are supervisory assistant.
Lordship,
Number 5.
number 5.
Okay. Now supervise is the status of the members of the shall be class 3 gazetted trade. The number of posts for recruitment to the service shall be made. Solicitor. You want in which post?
Lordship, civil solicitor, the next higher post,
From supervisory assistant.
from supervisory assistant to civil solicitor.
So let us see, solicitor by selection from amongst the persons who must have their solicitor with head assistant in the district sessions, head assistant and solicitor by selection from the persons who must have served as solicitor. How can a supervisory assistant become a solicitor of additional district court?
Lordship,
That is the post.
Lordship,
Okay, from head is supervisory assistant or solicitor of Munship or solicitor of assistant chief judge or continuously for yeah. Okay, then
Lordship, then Lordship, seniority, kindly come to page 54.
Huh?
54,
page 64.
Lordship, seniority, 12, Roman 2,
12.
then 1, A, B, C, then Roman 2, Lordship, 12, 2. In the upper division,
In upper division,
including solicitor of Munship, Canada, the seniority shall be according to the position in the select list, from which the promotion to the post of upper division assistant is made.
so you fall in the upper division.
Lordship. So seniority should be counted from the date of promotion to the post of upper division.
Upper division assistant will be okay, then
Lordship, then kindly come to my read petition, page 24, the gradation list. Page 24, Lordship, serial number 8, Shri Amar
what is
Chakraborty.
your name?
Amar Chakraborty. Lordship,
This is for grade 3.
Lordship, then name of the post,
Serial number
name of the post held at present UDA SA within bracket SA. Lordship,
where is your person?
Lordship, page 24, serial number 8,
Amar Chakraborty.
Amar Chakraborty, Lordship,
You are the UTA.
UDA.
That's supervisory assistant.
Then Lordship, appointment, date of appointment and promotion, LDA on 1/6/2006.
One
LDA
I was appointed as LDA on 1/6/2006,
1/6/2006,
then promoted to UDA on 1/3/2015.
15. Supervisory assistant on
On
21/12/2020. Then,
Next, Lordship, respondent number 6, Sri Iftikhar Azad. Serial
Oh.
number 9, Lordship.
9.
He was appointed as LDA on the same day as I
Okay.
was,
Ah.
1/6. But he was promoted to UDA
On
after
1/4.
1 month. I was promoted on 1/3/15, but the private
So
respondent,
rest are all same, but upper division appointment you are
I am senior.
Senior.
Lordship.
okay. Then is it on seniority come merit? Let us see again. Come back to the rule.
The Lordship, then
Recruitment is under what provision? For the purpose of promotion of supervisory assistant, so and so there shall prepare a sheet at the beginning of each year. Of the like.
Lordship, exactly a similar matter has already been adjudicated by a coordinate bench of this honorable court. Setting aside the selection lead. Exactly same selection list under the establishment of district and session judge.
And in page 25, you will find serial number 12. Arif Ahmed, he was also selected. He is in serial number 12. But he has not been made party to. His position is 12, but my position is
Let us
9,
see the impugn list.
Improved list at page 22, Lordship.
22.
Apera,
You are not there. Huh? You are not there. In the order it says. Move it.
no. Moreover,
Who is
Lordship,
appearing for the government? Government or the here? It's the High Court will appear. Yes. Why have you done it?
And in paragraph 6, there are the stand is there that although the petitioner is senior
I'll
to the
try. Phone number.
respondent number, respondent number 5,
5 or 6. 5.
5,
Please 5.
paragraph 6, page 28 of the lordship brief.
district and session judge.
District judge.
Yeah.
Is that
What is your stand?
the stand is, although the petitioner is senior to respondent number 6, in terms of the gradation list of the year 2021, selection board having considered the higher mark secured by it. So that's it. If that's accept that.
So where's the selection list? Not the selection list. Selection matters. Yeah. Let us see how you pick the 5.
Annexure 5. Page 32.
Not October.
The ground is secured higher.
This type of we have done. What is the judgment? So this judgment, this is the topic. Okay.
is that, the seniority should be merit come, seniority come merit lordship. So there should be a benchmark in, there should be a benchmark in the, for that is the qualifying mark. So if on the basis of that, any senior incumbent gets even lesser mark, still he should have been promoted.
Okay. Yes. Could have understood. Normally in the city and all, they have this mark of the so that
Well, there are two vacancies.
Huh?
Two vacancies.
are big.
The test of the poster, the two poster. And they two are here from.
City that here both of them are taken care. At least
Yes,
they are
my
they-
friend has not made party to the third one, who that is Speaker Ahmed, who was elected. He also occupying a post.
Who?
Serial number 12.
you are senior. You are not
I'm
challenging.
senior to him.
Understood.
Yes.
But you are not challenging him.
But I have been selected. Why should I challenge her? Because he ought to have made him party, my lord.
He doesn't want. Because if he very quick, like I know both of them, more Chakraborty and Mr. Azad has been taken up together.
Exactly.
They have the authority has not taken into account what was the name?
Yes, his case also taken up as a
No, very
yes.
it is who are the
In the minus to get it.
very definitely there. It kind of does say there's no mention of Arif. Is it?
But he was selected.
But under what position he was selected? Arif. what is the it, it,
My lord, we take you lot to our affidavit also, can you? Page 29, our affidavit, we have been paragraph 4, so we explain everything. And we have response
problem
number.
arises look to their own topic. Then
My lord, it is important to
four.
say, yes, paragraph 4. In reply to the contents of para 5, 4, 5 and 6, the answering respondent submits that respondent 5 issued a notice such and such interview to the deponent as well as the petitioner along with the other promotion to the next higher post by fixing 17 to 22 as the date of the interview. According to law 17 to 22, the respondent number 6
This
also.
matter is specifically taxed this time. I've been all along taking. Then we do one. It is minute. Why Arif Ahmed thing is not because
Yes, Iftikhar Azad. His name is here. It is to be mentioned that Iftikhar Azad, existing supervisor assistant, was already promoted to the post of the civil service.
Where?
In the paragraph.
Oh, this is you. Iftikhar Azad.
Yes.
Other person, Arif
Ah,
Ahmed.
Arif Ahmed, right.
Why he nothing is mentioned of
No fairness, but he was selected.
why? How he was selected?
That is the question. That's why he ought to have been made a party matter.
He need not make it. It- It is the same post.
Same post.
Civil solicitor are being paid. This person. It's the same post
Yes, which one?
to Arif Ahmed, which has been given. The same. Iftikhar Azad given to civil people.
Yes, so the Arif Ahmed Upper Division is notified the Munshi number 1, repeat, notified is promoted to the post of civil solicitor, the office of Munshi Pilasipara.
Well, he from Dhuti, na?
He's from Ruby.
He doesn't want to go to Pilasipara.
That's why, Lord.
That is why he is not telling.
That's why.
And
Exactly, Lord.
didn't he? Yeah. I dismiss, I allow his petition. But if it is
What will be my fate?
your faith is very simple, I have to do it. And take the help of him. Are you willing to go to your Pilas?
Wherever you lordship,
I
I have to
know.
serve. I have to serve. I'm ready to go.
Okay. Set aside this. Because set aside that by direct gain property. Now, I will only set aside as gain if petitioner hearing. Who is presently working as a supervised assistant in the establishment of the district and session judge for at 3. Being agreed by the promotion granted to the respondent number 6 by order dated 31, by order dated order bearing number 31 dated 3rd of March 2022. I have filed the instant petition. I've heard Mr. I Hassan appearing on behalf of the Mr. Hector appears on behalf of the respondent. Who also at 5. You appear for the High Court also, na? And what about the Section Court of 3, 4, and 5? As quote by appears for respondent number 1. The as Vishwas appears for the respondent number 6. The fact which is discernible from the perusal of the pleadings on record shows that the petitioner herein joined in the services of the establishment of the Justice on 1/6/2006 as the LAS, the post of the LB. Thereupon, on 1/3/2015, the petitioner was promoted to the post of upper division assistant. Subsequent thereto, on 21/12/2020, the petitioner was further promoted to the post of supervisory assistant. It is also seen from the record that the respondent number 6 was also appointed as an LDA, lower division, in the same establishment on 1/6/2006. However, he was promoted to the post of upper division assistant on 1/4/2006. Be that as it may, the promotion of the petitioner and the respondent number 6 to the post of the supervisory assistant is on the same date, that is on 21/12. The record further reveals that a notice was issued on 15/2/2022 for the purpose of filling up the post of civil solicitor.
That is not
Where the
mentioned,
notice
Lordship. That is not mentioned, the name of
it was issued, a notice was issued on when?
on 15th of February,
Where did
2020, page 21 of my decision.
a notice was issued by the respondent of the 5 intimating various officials, including the petitioner and the respondent, private respondent, that an oral interview of the governorship for promotion to the higher post was scheduled to be held on 17/2022 in the chamber of the district and section judge. The petitioner, along with the other, duly participated in the state election. However, pursuant thereto, on 3rd of March 2022, an order was passed, an order was issued under the by the respondent number 5, stating whereby the respondent number 6, who was junior to the petition, was promoted to the post of civil secretary to the office of the Munship number 1 Dhubri, whereas the petitioner was not. It is under such circumstances the petitioner being aggrieved have approached the court challenging the order dated 3rd of March 2000.
And his interstate seniority was also demoted.
Okay. Let us not. Sorry, I don't have the habit of that. Sorry, what's the relief? This court, by an order dated. The same petition was filed on 26/2022. This court, by an order dated 29/6/2022, had issued notice. This court, however, did not stay the impugned order dated 3/3/2022, but made it clear that the same order would be subject to the outcome of the petition. The record reveals that an affidavit in opposition has been filed by the respondent number 5. In the same affidavit in opposition, it was mentioned that though the petitioner was senior to the respondent number 6 in terms of the gradation list of the year 2021, the selection board, having considered the higher mark scored by the respondent number 6, then and finding nothing adverse in the ACR of the respondent number 6 for the years 2018, 2019, and 2020, promoted the respondent number 6 to the post of civil solicitor Bunsit Court UP. It was also mentioned that a resolution dated 17/2022 revealed that the particular cases of promotion, that in that particular case of promotion, the selection board had given weightage to the factor of seniority first and rather than merit for this particular case of promotion. However, as all the candidates appeared in the interview, the board considered the factor of merit to some extent and therefore decided to promote the candidate scoring higher marks, which is why the promotion was given. Why the petition, along with 2 other UD assistants who appeared in the interview, were rejected upon an overall assessment of their eligibility. This board have also taken note of the minutes of the selection board meeting, which have been enclosed as Annexure 5 to the affidavit in opposition filed by the respondent number 5. From the said affidavit in opposition, the said minutes of the meeting, it transpired as to how the selection committee had, on what basis the selection committee had prepared the respondent number 6 from that of the petitioner. Paragraph number 2 of the said minutes is reproduced here in below. The respondent number 6 has also filed an affidavit in opposition. Wherein it was mentioned that if the yardstick is when that the petitioner herein, the respondent number 6 herein was senior to one Arif Ahmed, who is not a party to the instant proceeding. In as much as the respondent number 6 is at serial number 10,
9.
is at serial number 9 of the gradation list, whereas Arif Ahmed is at serial number 12. The rest of the statement so made in the said affidavit in opposition by the respondent number 6 is in tune with the narrated facts for which this court, for the sake of brevity, is not repeated. The record further reveals that an affidavit in reply was filed by the petitioner against the affidavit in opposition filed by the respondent number 5. To the said affidavit in reply, the Assam District and Session Judges Establishment Ministerial Service Rules 1987 have been enclosed. Here. Have been enclosed. This court have also heard the learned counsels appearing on behalf of in the backdrop of the proceedings. This court have also heard the learned appearing on behalf of parties. And have it is the submission of the learned counsel appearing on the behalf of the petitioner, Mr. Goem Prasad, that a perusal of the Rule 6, 1, the note to Rule 6, the note to Rule 6, 1 and 2, bracket, would clearly show that the criterion for selection from the post of to the post of head assistant and solicitor of additional district judge and session judge is on the basis of seniority of merit The learned counsel further drew the attention to Rule 12, Roman 2, and submitted that in the upper division bracket, including the registrar of Munshi bracket, the seniority shall be according to the position in the select list from which the promotion to the post of upper division assistant is made. On the basis of the same, the learned counsel for the petitioner therefore submitted that as the petitioner admittedly is senior to the respondent number 6, the petitioner therefore ought to have been promoted to the post of the civil solicitor of the municipality, taking into account the criteria to be seniority of merit. The learned counsel submits that that when the criterion is seniority cum merit, the principle which requires to be looked into by the selection board is when the merit is the same. The seniority has to be given precedence. That in respect to the criteria of seniority cum merit, the selection board therefore it ought to have considered that the same principle postulates that given the minimum necessary merit requisite for efficiency of administration, the senior, even though less meritorious, shall have priority and a comparative assessment of merit is not required to be made. The learned counsel for the petitioner, drawing the attention to the minutes of the meeting, minutes of the selection committee, and more particularly to clause 2, which have already been quoted here in above, submitted that there is no mention in the said selection minute that the petitioner does not meet the requisite minimum criteria. Rather, the respondent have taken into account the merits vis-a-vis the petitioner and the respondent number 6, which is completely contrary to the service rules and the well-settled principle, relating to as to how seniority cum merit, how the criterion of seniority cum merit has to be adjusted. Anything else? Mrs. H. Sharma, the learned counsel appearing on behalf of the respondent for court, more particularly the 4 and 5, submitted. Fairly. That from the minutes of the meeting, minutes of the selection committee meeting, or the affidavit filed by the respondent number 5, it does not reveal that the petitioner did not have the minimum benchmark. He therefore submitted with all fairness that in such circumstances, the petitioner, who admittedly was senior, ought to have been granted the appointment. Mr. S.C. Paswas, the learned counsel appearing on behalf of the respondent number 6, submitted that admittedly the petitioner is junior to the respondent number 6 is junior to the petitioner. But by the same impugned order, another junior officer, namely one Arif Ahmed, who is at serial number 12 of the gradation list, have been granted a promotion to the post of civil solicitor in the court of Munsif Bilasipara. He submitted that as that the petitioner herein, that the respondent number, if there is an interference by this court to the order being passed, the petitioner, the respondent number 6, would be relegated back to the post of supervisory assistant, whereas a junior officer would be promoted to the post of civil solicitor in the establishment of the Munsif Bilasipara. I'll come at you. This court have duly heard the learned, this court have duly perused the materials on record of meeting, as well as all taken note of the content submissions made by the learned counsel for the party. A perusal of the rules of 1987 revealed as to how the recruitment is to be made. Rule 6 specifically envisaged. Rule 6.2 specifically envisaged that to the post of head assistant and the registrar of the additional district and session judge, the same has to be made by selection from amongst the persons who must have served as the supervisory assistant or as a registrar of Munsif or as a registrar of the assistant district and session judge or upper division assistant continuously for 3 years in the district and session judge established. The note appended to Rule 6.2 categorically mentions that the criterion for selection shall be on the basis of seniority cum merit, and the select list shall remain valid for 1 year from the date of recommendation made by the selection board. It is also seen from Rule 12 of the rules of 1987 that in respect to upper division, bracket including solicitor of the Munsif, bracket look, cadre, the seniority shall be according to the position in the select list from which the promotion to the post of upper division assistant is made. From the records available, more particularly the gradation list of the office of the district and session judge degree for the year 2021, it is clear that the petitioner hearing is at serial number 8, whereas the respondent number 6 is at serial number 9. This aspect of the matter is duly admitted by the respondent authority in the affidavit so filed by the respondent number 5. The question therefore arises in the instant case as to whether the selection so made was done taking into account the criterion seniority cum merit in the proper perspective. The criterion seniority cum merit have been dealt with by the Supreme Court in various decisions. In the case of D.V. Shivaya versus K. Adani Babu, reported in 1998, 6 SCC 720, the Supreme Court observed that the criterion of seniority cum merit in the matter of promotion postulate that given the minimum necessary merit requisite for the efficiency of administration, the senior, even though less merited, shall have priority, and a comparative assessment of merit is not required to be made. It was further observed that for assessing the minimum necessary merit, the competent authority can lay down minimum standards that is required and also prescribe the mode of assessment of the merit of the employee who is eligible for consideration for promotion. Further to that, the Supreme Court had also observed that such assessment can be made by assigning marks on the basis of appraisal of performance on the basis of the service record and interview, and prescribing the minimum mark which would entitle a person to be promoted on the basis of seniority cum merit. Paragraph number 18 of the said judgment, being relevant, is quoted, reproduced hereinunder. In the backdrop of the above proposition of law as settled by the Supreme Court, and the same being applied to the facts of the case, and more particularly to the minutes of the selection meeting held on 8/2/2022, it would show that the respondent number 5 it would show that the selection committee did not observe that, did not come to a come to an opinion that the petitioner herein did not have the minimum necessary merit requisite for the efficiency of administration. The record further revealed that there has been, that the responding authority, that the competent authority did not lay down the minimum standard that is required, and had also prescribed the mode of assessment of the merit of the employee who was eligible for consideration of promotion. On the other hand, a perusal of paragraph 2 of the minutes of the meeting held on 18/2/2022, 8/2/2022, which have already been quoted herein above, shows that both the petitioner as well as the respondent number 6 have the requisite qualification, and as such, they were interviewed. However, on the ground that the respondent number 6 was found eligible for the post of civil Seristadar of Munsib Dhubri on the ground that he had scored higher marks than the petitioner, the respondent number 6, it was recommended that the respondent number 6 be promoted to the post of the civil Seristadar of Munsib Dhubri. In the opinion of this court, the manner in which the assessment was done was not in terms with the criterion laid down to the effect, criterion laid down, that is seniority cum merit, as well settled by the Supreme Court. Under such circumstances, this court is therefore of the opinion that the instant selection the selection which have been made in favor of the respondent number 6 is required to be interfered with. Full stop. Accordingly, this court interferes with the selection in the minutes of the meeting held on 8/2/2022 insofar as the selection of the respondent number 6 is concerned, and further to that, and consequently, this court also interferes with the order number 31 dated 3rd of March 2022 insofar as the respondent number 6 have been promoted upgraded to the post of civil solicitor in the office of the responsive number 1 Dhubri. This court further directs the district and session judge Dhubri to carry out a fresh selection on the basis of the observations made herein above, and the same be carried out within a period of 3 months, 2 months from the date from today. Oh, no, so if you are there, you can intimate. Oh, no, 2 months from from the date a certified copy of the instant judgment is served upon the respondent number 5. This court, before parting with the report, this court also finds it very pertinent to take note of by Mr. S.C. Biswas, the learned counsel appearing on behalf of the respondent number 6, who submits that one Arif Ahmed, who was junior to the petitioner, have been to the respondent number 6 have been promoted to the post of civil solicitor. In the office of the Munsif Bilasipara. This court have duly taken note of the selection which was carried out in respect to the said Arif Ahmed. And from the record, it reveals, and from annexure 8 to the affidavit filed by the respondent number 5, it revealed that the same was a separate selection proceedings, which was held on 17/2/2022. The petitioner, the respondent number 6, if so agreed by the promotion of the respondent by the promotion of Sri Arif Ahmed to the post of civil solicitor in the office of the Munsif Bilasipara, the respondent number 6 would be at liberty to do so in accordance, if so permissible under law.
Item number 5 to 7.
Yes,
My lord, the other day, lordship, just give me some homework regarding, my lord, that package certificate is the default or the due, my lord.
Huh?
Lordship gave me the homework to see, my lord, package certificate in respect of default or maybe due anything, my lord. This judgment by the division bench, I just please, lordship, my
Take what you.
Paragraph 14, my lord. What? Page number 7. 2020. 5 GLR 135. 130. Para 4. Right. A package clearance certificate is required to ensure that there are no dues payable by the applicant bidder in respect of any revenue to the government. In short, the package clearance certificate can be termed to be a no dues certificate issued by the competent authority of the government. The petitioner submitted a package clearance certificate issued by the package officer of Corporation Department, not Sarmara Hoyapur, which was rejected by the official respondent. A bare perusal of the Assam Fisheries Rules 1953 revealed that there is no specific requirement regarding submission of package clearance or no dues certificate. However, considering the fact that purpose of settlement of a fishery by the government is to earn revenue, a no dues certificate cannot be considered to be totally irrelevant for the purpose of settlement of the fishery. The pleading do not reveal any aberration that any dues revenue payable by the writ petitioner, respondent number 8, has remained payable to the government. No such allegation has been made by the writ petitioner or by state authorities in respect of number 8. It was open for the official respondent to make necessary inquiries to find out if there are any dues payable to the government by the respondent number 8. My lord,
What is this?
my lord, this is in the second case, my lord. This in page number paragraph 7, my lord. Paragraph 7 in the middle next page. In the middle, just one sentence, my lord. That is, my lord, your lordship's judgment was passed in a single bench. Regarding Bakijai clearance certificate, it was not produced along with the tender paper. Lordship dismissed that case. The other side went to the writ appeal. So the writ appeal stage, my lord, lordship division may just appeal your lordship's judgment. But that comment about that Bakijai certificate, my lord, lordship will find in paragraph 7. Paragraph 7, it's a long paragraph, my lord. It's in page number, it will be in page number 10, my lord. Page number 10. Page 1, 2, 3, 4, 5, 6th line. 6th line, my lord, page number 10. The Bakijai clearance certificate is demanded to ensure the financial stability of the bidders, my lord. That's what I want to provide. Here, your lordship has seen, my lord.
Paragraph 7, what does it say?
Paragraph 7, my lord. Relevant will be in page number 10. 7th line from the top. 7th line from the top here, my lord. Page number 10.
Yes. What does it say?
The
You have to
Bakijai
confirm
clearance certificate is demanded to ensure the financial stability of the bidders, my lord. Lordship has seen, my lord, their audit report.
No, we are not concerned with the whether the Bakijai certificate is required or not. We are not concerned. We are concerned as to what is the effect of a Bakijai certificate. Just for example, a person, are you saying, or is it the government stand out here to say that whatever may be, a person cannot even take a loan?
No, they can take a loan. There is no doubt about it.
Yeah.
From 2017 onwards, their own document in writ petition, page number 45. 17, 18, 18, 19, 19, 20, default, government in interest is increasing, it came to 80,000. Page number 45, kindly see, my lord, in the writ petition. That's what. In their own document, page 45, my lord, kindly have a look once. Page 45, my lord, kindly just have a look. 45, it's in Barley corner, my lord. Let's have serial number 5.
Page 45, which
46 writ petition, my lord. It
Yes.
starts in page number 45.
this is the comparative chart.
No, this is the
Which writ petition?
audit report. It is writ petition, my lord, 1891. Pioneer
No,
1891.
we are concerned with that. Yours is 421, 4205.
No, my lord, this is 1891.
Who is the wrong? And yours is? You are number 2.
Yes.
1891.
Yes, my lord, page number 45. These are audit report we have to submit along with the tender paper, my
Yes, page number.
page number 45. See the top 2017-18 top year. Page 45. On top there is a year, my lord.
45. Yes.
Yes, my lord.
2017.
Yes, 18. Come bottom, my lord, serial number 4. Sarkari Hood 2389. Now come to next page, my lord. This is signed by Shuman Das, my lord, secretary of the society. Come to the next page, my lord. Kindly in the left side, page 46, serial number 5, 43,098 rupees.
53,000.
Yeah, 50,090. Next page 49. 49, my lord. This is the certificate issued by the Konishta Senior, my lord, Hishab auditor of the university. See,
Certificate. These are not being put in English.
my lord, their petition.
Mr. Monta, why should this court look into all these things?
Serial number 4. Serial number 4. Then page 51. Again in page
Page number 43. Page number 43 is a type copy of what? Mr. Monta,
My lord,
It's a parent.
Huh?
balance. I think this is a type copy of page 44, my lord. Probably. Let us see the figure 45. Yes, my lord. Yes, page 43 is of 44. Related.
no, understood one thing, but why then why they have not mentioned it should be a no-use certificate with the notice? Let us what is the exact word you in that particular book. Serial number at the architect clearance certificate, the deputy of the
Yes. Yes.
now and where what it means it गीता ऊपर चलो प्राप्त जय
Jai Mukta
प्रभात पत्र. Now, if the tender says that Pakizai certificate is to be given by the deputy commissioner, and the deputy commissioner has given the Pakizai certificate, and what is the Pakizai certificate actually? You see, the question of no dues cannot be brought in. You can't bring in the no dues because the tender is very clear.
My lord. Can I stop?
Yes, please. You are at liberty
No,
to
no.
submit.
That's the beauty of a notice, my lord. In this court, my lord. We are so often left open to argue, my lord. Lordship is the division with judgment, my lord. What the purpose? The purpose. Suppose, see how Baki certificate is we get, my lord. This is the form. Can you have a look once? You have to give statement in the form and in the affidavit. Kindly see this example I am showing. I have got 2 examples. My lord, see the form. Application for Baki clearance certificate. Come to the bottom, my lord. Serial number 3, supporting document. Lordship has seen that, my lord. Now, serial number 3.
Any other
Yes, come on the last page, kindly see, my lord. Last, any other document, there's an affidavit.
So does it say that the affidavit says that I have no dues?
No, kindly see. No due. But here, lordship has seen what the affidavit. In my case, my lord, kindly just take a look. Another one.
Is there a format for the affidavit?
My lord, there's a format. It's in the computer. If we tap out, my lord, this is the format.
Is
This is
there
the
a
format.
no? For this application, is there a format for the affidavit?
Format for the affidavit, I searched, my lord. I
No,
could
no.
not.
If it is not there,
Hmm.
you have. This is whose whose affidavit? Is.
This is all my learned friend has got one of.
Anyway,
How it is.
so
See the
this is-
second copy, my lord.
Here he says that I'm in no way liable to the state of Assam or any other financial institution.
Yes.
That is okay, not liable.
Hmm.
But here, if the format enclosed to the Bakizai certificate application would have shown that it has to contain this particular statement, then obviously you may have a
This is one by the respondent number, private respondent in this tender, my lord. This is one, kindly see his statement. Probably. He writes here, my lord, no Pakijai stroke loan in the name of Pakpuri Mini Samiti and from father, mother, sister, my lord. That's what I want to say, my
No,
lord. Some-
therefore, the question is, what is the Bakija certificate?
because when you give a statement with a declaration, statements are true on the basis of
What
your
is- wha-
application.
does the application say that you don't require any certificate? That there is no due?
Suppose, my lord, let us see from the other angle, my lord. Suppose I am supposed to give, just like his case, my lord, I am supposed to pay loan to the government. I am defaulting, right? When there's the defaulting, but when you fill up the form and you write that no dues are payable by me. Now the authority in the disease office, when they find your application like this, my lord, yes, this is the statement, I give the certificate. But the fact remains that government loan is due from 23,000, it has gone to 80,000 rupees. Hereby your number of interest is increasing, you are not paying the government loan. That's why on the date of opening on the tender, which on 28 to 2022, my lord. Lordship knows in
No,
any
on
tender.
this certificate, it does not show, or from what you have shown, it does not show that a person concerned may show in his balance sheet, yes, I have to pay this particular loan to this amount and this is the interest. He may very well show. But the interest amount out there to be paid, would it show that he is liable or he is in default?
From 2017 onward, the amount is increasing and increasing and increasing.
Obviously, it will increase.
Unless you pay, that's why the government says,
No. Just for example, tomorrow you take a loan for for buying a house. In your balance sheet, you will see this is because what happens when you are paying in installment. First, the interest portion is being taken. You see the interest. First, the interest will be taken, and then coming down, the principal becomes more interest. This is how it is when you take any loan. Now, what happens? Because there cannot be an interest on interest. So what happens? The first the interest is being taken up. Just for example, you have taken 10 lakh. You have to pay. Now, your interest portion, which comes to otherwise is around 35 lakh. That's the interest. So what will happen first year? And your installment is 5,000. So they will first accumulate 200 or 400 from the principal and have a higher amount in the. Now, accordingly, the interest will always be took out there. This is the interest which I am due in your balance sheet.
but the authorities here, Lordship has seen, they given a certificate, they are a defaulter. Even the comparative statement, there's a column, my lord, defaulter. On 28/2, when the tenders are open, all the parties are present, then we can raise objection. On that, the objection raised. Then this immediately asked the CS, my lord, that cooperative department, verbally instructed, it is written there, verbally instructed. You furnish the report, whether the report or not. Then the assistant regiment inspector, he furnished the report. Yes, they are defaulter, my lord. That's why they put a question came.
Who has submitted? You have got a record.
In my affidavit, I have given the, my lord, that copy. And lordship also can see one thing, my lord. What affidavit is submitted, my lord. If he says that there is not a defaulter.
No. Are you saying you passed this order on basis of the challan of 18? You passed on the basis of the challan, not on the basis of the report. Then where is the report? That is why I've asked you for get the report.
They filed an affidavit today. Yes, sir. That copy has been submitted.
That's okay. But first,
That report I have annexed in page number 220, my lord. That explains
that
it
will
as
be.
well.
When this court is directed to, what is your basis? Your basis is to challan. I've asked you to bring the records. What is my order? The Eastern Register of Property is directed to file a short affidavit as to whether there is any backstep proceedings indicated by the office of the against the against the truth of which the basis of which the report dated was made by. Yes, we have submitted a report. Was there any backstep? Then the Deputy Commissioner is further directed to produce the records on the basis of which the communication dated demand was issued to the Commissioner and Secretary General. So are you saying that your basis of this record is this to challenge nothing else? Then we have to say that if these are considered, these are happening out there, that is not a part that have been mentioned out here. So under such circumstances, the records does not support the passing of this order, and as such, this order is bad, and consequently, the action taken on the basis of this order is bad. There's no way out. Where is that?
That is page number 220.
The Deputy Commissioner has not given. Okay, we call the District Commissioner next time. Yes, we'll get at it. It
Well, it may not be in your lordship's file, it has not come probably.
we have a copy of.
I may just give my copy, my lord, if they have an extra copy. Otherwise, his lordship may see it. Paragraph 3, they have specified that there is no particular prohibited.
But if you are if the party they carry certificate for required, unless there is an education that the party they carry certificate has been obtained by fraud. That is, where's the education of the government? Delegation, they don't even have the record. There's no Pakita clearance. Pakita. They don't want to produce it. So therefore, we have to hold it. That there's something to drop up and again. Now the question is, the Pakita is out there. If the tender does not say anything, let's say about the notice, that it says the Pakita Mukta. If it is not started, so under such a why you can't on the basis of a condition of a tender which does not exist qualify.
There is the division which says
Division
In
bench
short,
says whatever may
the
be, it will again go to
certificate
division
is
bench.
termed to be not used. So to go by the
That
system.
is on a different thing. Can you incorporate something in a tender document which is not there? Is it the duty of the judicial court to do that?
Or my
Whereas
lord,
rightly from all the things.
or my lord.
Or is it the understanding of the authority? Not you, of the authority. That the Bakizai clearance certificate means no due certificate?
My lord, can I submit one thing? Subject to lordship's correction. One thing. Can that affidavit or the application can be called for my lordship? You can see from there if the statement is there. Or then the truth will be
All
there.
from whom?
The authorities to whom the package certificate, DC office will be found. It is obtained from the replicant.
When the DC is not producing the record, what is there to call for?
Ultimately, your lordship's hand, my lord. It is not short, my lord. Very long hand lordship has got, my lord. They cannot say. They cannot, my lord. I can tell
The
you.
consequences of this is very, we'll have to hold it that the district commissioner has not produced us for withdraw presumption. Is it the statement? Have the deputy commissioner or the fisheries department filed an affidavit that the Bakizai proceeding the certificate was obtained fraudulently? No, that is not their case. What was required was a Bakizai certificate. That was duly given. Where do you incorporate another aspect of a no due certificate? Mr. Nath, that party, you are fighting a case, and although in the field those people are helping you out, but here nobody is doing.
But one thing, my lord.
That is the
As I know your lordship's, my lord. As I know your lordship's, but to be very honest, it is impossible for the respondent.
Huh?
It is impossible to simply for the respondent not to comply with lordship's order. That much I can.
That is different. I know, but why should I?
Immaterial, my lord. Whether
No,
I
no,
win
no,
the
no,
case
no,
or I lose the case,
no.
my lord. Justice should be prevailed.
No, Mr. Nath, yeah, the petitioner is before the court.
But
Petitioner has
no,
faced all the
Take into
materials.
consideration the entire
They have
scenario.
not done anything.
And
The state, therefore I'm saying, on the field, these people are supposed.
But
not
this will be so tired, my lord. Before your lordships, I don't think, my lord.
No,
As
why
IAS
should I
officer,
exercise my flex my
to
muscles
find out the
inform
truth,
you?
my lord. To find the truth, my lord. That's all. Immaterial, I win, I
The
lose, my
truth
lord.
will be
Justice should be
always there.
prevailed, my lord. That's all.
Truth is
Immaterial, I
always-
lose or
But
lose.
the fact is, yes, truth is that you obtain the Pakistan certificate. Yes, just for example, this application you have given to me, it contains an affidavit wherein it says that I am in no way liable to the state of Assam or any other financial institution. Is this the requirement of the Pakistan certificate affidavit?
What happens, my lord, during the proceedings, many things comes out, my lord. Where is the truth to find out? Initially, lordship will see very green picture, my lord. Slowly, oh, you go deep into it, find the truth. There is the truth. Maybe against me, maybe against you. That's how our lordship is got, my lord, not doing, my lord. Can any order, judgment passed by lordships, my lord, we happily accept, my lord. This is the system, my lord.
Let, if I may come in.
Yes.
Let, it is a court of record. The record reveals now that Pakizai certificate is required. My learned friend is insisting upon interpretation of Pakizai certificate and all that. I have a decision of this honorable court division bench decision where it says that even this is not relevant that way. To that extent, Pakizai certificate also, you cannot interpret it that this is mandatory, it must be there.
No, thereafter another judge, has said it's not going into the
Well,
question of mandatory.
I am just saying,
No. It's not the question of going into also the question
yes,
of the fact that you have submitted the Pakistan.
exactly.
So the question arises that if the authority has said, or if it's the stand of the court that the Pakistan certificate was fake,
Yes.
or false, or obtaining the Pakistan certificate has taken constant.
Exactly.
If that is not the case,
Then,
then if it is compliant with that, can you incorporate
yes,
any views from the state,
exactly.
whatever may be?
Yes. And Lordship wanted to confirm it from the cooperative department, whether there was any proceeding pending on that day. They have said now in the affidavit, no, nothing. Now, A businessman may have so many dues in different departments. And that will be going on paying and regularly.
No, they
Unless-
could have very well fit in the that they can move
Exactly.
to pending against the state
Yes.
or independent.
Then the matter would have been
Not
different.
apply. They very well put. That was
Yes,
not the constitution.
No,
But you are a very yes, look at me. Get the- You are the main person who have done everything.
yes.
How can you incorporate another condition which is not a part of, unless you say
Yeah.
that the Pakistan proceeding certificate, which they have used, is a fraudulent,
It is
which
not
you have
pro-
not. Then
If there is no Pakistan proceedings, if there is no Pakistan proceedings pending, then it cannot be said that there is Pakistan.
obviously the Pakistan officer will come into the play when there is a Pakistan proceeding.
Yes.
certificate.
Yes, sir.
So as of now, there was no proceedings which was sent out there.
Yes, sir.
So how can he take that yes, there is a loan? But you ordered, you may have, but you have to.
Yeah.
You have not put that condition that under such circumstances, whatever. Yes, the division bench says that what is the meaning in the different context. That what is the Pakistan, something like a note to certificate. But can this court read the judgment of whatever court as a elusive theorem, which the Supreme Court says you cannot?
Pakistan, in my case, I have appeared lot in division bench. In one of the case, in two-pit system, the division bench says it is mandatory because we don't know.
No, Pakistan. No, see, if the whether the division bench says or not, in my opinion, when the authorities think it to be mandatory, it is mandatory.
Yes, Lord.
And for this court, so I'm not on that mandatory authority.
Yeah.
But the question is, because as of now, earlier at one point of time, Kotak ties and all where there or the GTA Patatas where you could have, but the recent judgment of the court and all, you cannot.
No.
It is not within the jurisdiction of this court or the seat as to whether it is mandatory or that.
Yes, sir.
Now the question is, you only hold a particular term that you need a Pakistan clearance.
Yes.
Is it your opinion out there that the Pakistan clearance certificate have been obtained by fraudulent? No.
No.
Or is it your case out here that the deputy commissioner says that my office has been wrong in giving the Pakistan clearance certificate? No,
No, I think
it is not his name. So under such circumstances, how you could reject the petitioner?
it is a old matter. I leave it to your lordship. I leave it to I leave it to your lordship. It is. I agree
Now
with
the
it.
second consideration is that is okay. How does this court interfere? When I interfere. What is to be done? There has to be a fresh election,
Because it is. I think it is 2019 matter, lordship.
but there has to be a fresh. As
Well,
of
Because the rate are enhanced.
the rate will go up. The rate cannot get
That
rates have to go. Now the recent judgment of the Supreme Court in the case of maybe it's Tata thing, Tata Power versus Best. Tata Motors versus Best. Yes, sir. So there what happened, the division bench of the Bombay High Court said that okay, let him get. Yes, people say that no, you have no business. It's there. Secondly, there is another judgment, the Dixon judgment that Yeah. So there also it has been said that it is not for the court to direct the authority to settle with something. So the consequence will be that they have to go for a fresh. That is the only.
May not be recorded, but
Now whether I record or not, you are there on live streaming.
Yes,
Yeah.
my lord. Nowadays, client became so smart in all the case, my lord.
Lordship, it
Before
is-
we go to the court, my lord, it will
Lordship,
come, my
it-
lord.
Lordship, it is
Very
up to-
smart
up to
to
your lordship, lordship. It is up to your lordship. Because
No. The
it
thing
is for the revenue of the
you
government.
can put any term and condition, but the question is cannot, because it will be incorporated. Say, okay, you are bringing a no use certificate. Tomorrow you may bring something else.
Yeah.
Can this put here? This one. Let the Supreme Court say. Yes. In this case, the High Court by the impugned judgment and order could not have to the abandonment, the instrumentalities of the state to enter into a contract which was totally harmful to the public interest. Inasmuch as if the power of its electricity to be procured by the procurers at the rates set by so which is higher than the rate set, that the state would have been required to bear financial burden to procurers, which would in turn us by. As such, we are of the considered view that the matter must be by the court issued by failing to take into consideration the larger consumer interest and the consequential public interest. Here, the question would be the rate which they had quoted at that point of time. It was 4 years back. Okay. So now it would be different. So there has to be a fresh. Now the question is, within what time are you going to hold the press call for a
Lordship may put 1 month, one to 2 months, because election is coming. Next 1 month. In 1 month.
Let yeah, my first submission would be injustice was done to me. I approached this honorable court. Now, the principle on which the first court in that particular case say regarding processing of electricity power. Here, Lordship will find I was the second highest bid, much above him. And if a Lordship look into the other side, without getting this woman on daily basis, he has run for 3 years, causing heavy loss to this state. This last thing from the death of Biden. To that extent, my bid would have been much above. Therefore, even it will commensurate now in the present state. In the present day also, the bid I have quoted cannot be said that this is too bigger. My full submission is that the bid I that time submitted being the second highest bid compared to the bid submitted by the respondent who has run it even on daily basis for last week. It will first dividend to the public exchequer. Public is not going to suffer.
So now the thing is, between this period, what I did, what is going to say the second? But they are again allowing them to.
In 1 month, Lordship, you can go for the tender. Tender.
But the first thing,
Last time, my lord, he said that. Last time, what happened? September order made of 25 to 21 and 26 to my lord, the notification came out. That's why it could not operate. The government said, whoever is running the fishery, you are running. My lord, that's the reason why. And thereafter, 22 to 321 after next month election, it has gone.
Now it is
That
a
was the
better position, my lord. Lordship will direct that until they complete the process,
Lordship, can you give me
this
2
second
minutes?
highest bidder, who is a valid bidder at that time, illegally rejected, should be allowed to run the market. I mean,
Can I give it 1 minute? Lordship?
I think that will be
Can I
the,
make a call, Lordship?
You take it up. Keep it. Read it.
they can take their time. Meanwhile, Lordship will direct them. At least that will bring some benefit to the public.
Understood, but thing is,
That will not
we
cause
are in
any
a
damage.
very. I have taken up this matter the way
True, my
it's
lord.
a matter with the public.
My lord, this is process, my lord. Despite all effort, the matter could not be heard. And that's how ultimately the people suffer. Somebody makes some gain out of nothing, and somebody keeps on suffering. This is the situation. Therefore, my lord, my responsible submission, equity will be served legally, law will be met. If Lordship directs that the
No,
petitioner,
but that would be a bit difficult.
my lord, in my responsible submission,
Think about it. Tell me at the 350.
Well,
Would it be possible as a senior?
my lord,
Not as a tax, not as a council.
in all such cases, this honorable court was directing, issuing such direction,
I give you 15
leaving
minutes
it
of.
to the authority.
No, Mr. Mohanto, kindly. 315. What best for that? Tell me. Hear it.
My lord, I will definitely say, but at the same time,
But you have to also appreciate the constraints of the power of this court.
my lord, that is why I am not saying that Lordship will
The moment I give it, you are not going to get anything. I'm telling you.
Well,
If I give that also, you won't get because they will file an appeal and it get a state on that bit.
my
And
lord,
thereby the matter
Well,
would go.
therefore, Lordship may say, my full submission, that until again fresh arrangement is made, for the time being, at least the better arrangement is the second highest bidder, who is the least highest bidder, he should be allowed to run. Let them take the call at any time they want. 1 month, 2 months, whatever they want. Because now going by the
you
time,
just-
because it's 7
no,
years.
Mr.
my
Mohanto,
term is
you-
7 years.
Mr. Mohanto, you come at 315, but just give a thought to this thing. I can direct you or anybody submit an application, submit a representation before the authorities as to how much during the interim you are going to pay, and the authorities can decide on that. Then in that regard, it will be with the authorities to decide, then you can do whatever. I think that is the best way. Anyway, that's 315.
I have taken the inspection, Lordship.
Ah,
The additional secretary has stated
ah.
that we will direct within 7 days. After getting the suspect copy of this order, it will immediately direct the DP to hold for the name.
No, that is okay, but yeah, 350. Give me those matters of these are disposed of. Put it off. That but yes, 350. Yeah. Yes. Primarily, I find that during the interim, if it cannot be settled immediately, the authorities should take a decision on the basis of a representative as to what amount they are going to. And also, any better ideas?
Let us think.
Whose matters are there?
14 to 18.
Item in 14, my lord, government has recently filed affidavit in opposition.
What is the matter about?
Matter is, my lord, Adabari bus stand regarding that plot of land, my lord. That was initially requisition order was there. Subsequently, in the year 2007, my lord, it was, my lord, by way of land acquisition, my lord. By following the notification was published,
2017 or matter? Yes, then what up?
and thereafter, my lord, they have calculated, my lord, the amount of compensation it is payable to us, my lord.
Huh?
The amount of compensation, my lord, award amount has been recently calculated by the government, my lord.
Then?
Pursuant to the honorable court, and that has been already pending, my lord. That is only my case, my lord. Requisition compensation and a land acquisition award has not been released to us. Amount has been already sanctioned.
Sanction has been given.
Yes, my lord. That is in the affidavit opposition.
Yes.
That is yes.
I did 3 repetitions, 4 repetitions.
Others, my lord, some of the legal heirs, my lord,
file lead petition, my
You
lord.
are appearing in 2009 matter.
Yes, my lord.
Who is appearing in 2007 matter?
I am appearing, my lord. I'm the rest.
You are for the
Okay.
petitioner.
I am for the rest of the cases, but I am for the petitioner. In fact,
Petitioner.
I should go that side.
Better. That is what. I think
But in that case, my lord,
these two are petitioners. Then 2010 matter,
Yeah, the same, I also.
you are there. And 2013?
All the rest are.
rest of all my senior. friends.
Yes. Let's hear Mr. Roy. Yes, Mr. Roy.
No, okay.
Yes, why these
Well,
matters are pending?
Uh, in fact, we also filed some petition for expeditious hearing was also filed. The government will not sometimes wanted to file an affidavit. They have now filed.
Whether the government does or not, we are not concerned. Who is appearing for the revenue? And which department?
The dean not file affidavit.
Now, which department is this? Huh?
My lord,
Senior government advocate.
my lord, it's like this, my lord. I just He will also-
That is appearing in this matter. We have filed our affidavit. He's on late in Kota, but 12.
Now, who is the requiring authority?
the GMC.
GMC. So nobody appears for GMC. Yes. Okay, we hear it. You are there for the revenue? Okay, Mr. Corporator, you come in. Don't request. Now, what has happened to the acquisition proceeding?
It's on 2007. My
Mr.
My lord,
Corporator,
it happened like that. In 1986, my lord.
Yes.
Our lands were, requisition. A total 59 bigha and odd,
under 64A.
64 or something
Yeah.
like. Then for construction of bus stand there. The 1988 bus stand was constructed. Then after the construction, some land which belonged to us remained. They did not use that land, my lord. We made a prayer before the authority for de-requisitioning the land since they do not need the land. They never needed the land. The authority DC additional, we made a prayer before the GMC. GMC made a recommendation to the DC addition DC. And then before the DC also made a representation. Based on that, they have de-requisitioned the particular land, 7 bigha and all. We thereafter, my lord, after obtaining permission from the DC for selling the land, we have sold. The petition number 1 to 5 were the owners and the rest are the purchasers, my lord. Thereafter, my lord, they went into the land, forcibly taken over possession. And we filed an FIR and all. We filed the petition. There is an order passed by this honorable court, status quo. Then thereafter, this honorable court has given a direction to consider the representation in the meantime. They have disposed of the petition, deciding against us. We filed another petition challenging that order. And then, my lord, after 5 years, they passed an order cancelling the de-requisition order, saying that they needed the land for construction of bus stand. Now they need it for construction of a park. The requisition is always temporary in nature, my lord. It can't be, it's not acquisition. It's temporary. They said they need it for construction of a park. And thereafter they issued section 4 notification, though ought to have been issued under the same act, my lord, 64 Act also.
Okay. They went for section 4.
Section 4.
Then
we challenged that, my lord said, the purpose was originally for, my lord, construction of a bus stand.
Then did the section
And
6
they said they will shift it to some other place. They need this our land, 7 bigha and all, for construction of a park. So on that basis, my lord, we have filed all those petitions, my lord. They one after another order was passed. First, they attempt to occupy the land. This one court passed an order not to disturb our possession. Then same order, interim order was continued in other cases also. The last case, in the last case, 2013 case, we challenged the notification under section 4. That is the
section 4.
4 of the LA Act.
You challenge.
Challenged it. Tell us.
Why? There is no public purpose.
No, no public purpose,
But
because the land is you.
whether they have initiated the Section 4 notification was preceded by or did it contain the waiver of 5A?
Only they said that there's a section 16 waiver, section 16,
Section 17 waiver.
17 waiver. That is,
So they have done so.
they have done.
Did the declaration under Section 6 come?
No, my lord. On that stage only we have come here.
But
No.
was there a stay to the Section 4?
There is an entry because this honorable court passed an order that the earlier interim order would continue. So my lord, status quo
So Section 6 did not come.
did not come.
But was there a stay not to go ahead with the acquisition procedure?
There is, my lord, perhaps, my lord, because they did not go ahead.
No, there cannot be.
No, because they earlier also.
Because you see, no, why I'm saying, Mr. Roy, as of now, the 2013 Act has come.
New act has come.
Now, why I'm saying, if there is no order passed for acquisition, no order has been passed under section for staying the acquisition proceeding or the notification under
Because this
section 4.
petition was filed, my lord, prior to the.
No, if there is no notification, there is no challenge to, there is no stay to that. Then
that
in
particular.
then in that regard, section 6 will hit in and the section 4 notification will go.
Oh, that's right. my lord.
Because
That's,
1 year is there.
Lordship has rightly pointed out, my lord.
So section
this
4 will
aspect, my
go.
lord, I think I need to examine, my lord.
No,
Lordship has-
don't examine. I am here to examine.
Because in fact we have
The 2007 matter, the
we are
moment I saw
basically
it in the list,
against the derequisition
I saw
cancellation.
this 2007 matters in the list. at 2 PM. I was thinking, how many matters?
No, my lord,
let us see.
my grievance is against the derequisition. They cannot derequisition. They after that, when what the legal position is, after the derequisition order is passed,
Have you been paid any amount during the derequisitioning? Or any amount till date have you paid?
Who
Accus-
installment dependent?
Huh?
Who installment dependent?
When?
my lord, requisition compensation and acquisition compensation are two different. Requisition
No,
compensation
that is another. That is another. Acquisition compensation has it
is
been
only rent, my lord. Because
paid?
their status is only licensing.
Yes, on the rent. Have they paid any amount?
Who installment depend first, madam?
How much?
Madam,
One person they've given to them for distribution. I'm not sure whether
they have also.
I can't.
Now, why you are there, Mr. Das? For whom are you appearing?
We are detail here, madam, power of depend first. Only madam detail here, madam, thereafter.
You are the power of attorney holder.
Of the 19th. And out of them, they madam took that.
What are the names of the legal heirs?
Any.
Any name?
Police or power.
Ball. And power of attorney holder name?
Power of the police or power of.
And who is the legal heir name?
Other legal heads are all there. I have. checked the-
One name.
Yes, Haru Devi pilot.
Ah,
From
okay. Yes. Yes, Mr. Roy, please. Yes, what has happened to the acquisition?
Your Lordship is taking up the first writ petition item number 1925.
That is what.
Yes, their Lordship may kindly come to page 237. That is a part of the affidavit, running page number 237.
That's
Right.
fine.
1925.
Couple of order passed. That is. Therefore, I appear to rule on the first date itself. There is no interim order here. What is being challenged here, let us. I return to pay acquisition compensation for entire 9 acres of land. Yes. So, I have by the sale deed or any other deed in respect of titular should not be set aside at all. Who has filed it? Who has executed the sale deed?
Because
You have challenged the sale deeds executed between two private persons.
Yes.
Why here?
Because our de-requisition order was already requirement.
Understood, but how can you challenge all these things here? How can the sale deed be set aside by writ court? As
But
to
that's not
why a
correct.
writ
Yeah,
should not be issued for direction to pay the requisition for. So this matter pertains to non-payment of requisition for.
Yes.
Now, yes, you are saying, okay,
So, can you kindly come to running page number 237?
you are saying. Yes, what is it?
This is a part of the affidavit pilot filed by the ABC, Land Acquisition Branch, Kamrup Metro. If my lord may be pleased to read paragraph 16.
Paragraph 16, there's no paragraph here.
Page 237.
I think page 237, I've seen it. That is the representation.
No, my lord, here it is. In my copy, my lord, it is the affidavit. Otherwise, lordship may take out, my lord, the affidavit filed on 7/11/23. The deponent is one Priyanshu Bharadwaj.
Huh? Recently filed.
Yeah.
Filed by
My lord, the deponent is
Priyanshu
one
Bharadwaj.
Priyanshu Bharadwaj.
Who has filed it? The number 5. Who is it? Additional 60.
It is me. Here, lordship may kindly come to para 16.
Para?
16, 16. I'm reading it, my lord. The land measuring 52 biga 1 kotha 8 lesser has been acquired by LA case number for construction of Adabari Bus Stand Park in village Gorpandu Kumarpara under Moda Dalukbari as per provision of Land Acquisition Act 1894. Accordingly, government approved notification under section 4(1) of LA 1894, height number so-and-so dated 6/8/2011. Again, government approved the declaration under section 6(1) of the LA Act of 1894, height order dated 14/11/2011. The land valuation of the acquired land was fixed for rupees 2,70,000 per kotha, and accordingly land acquisition estimate amounting to rupees 11 crores 2,49,000 so-and-so approved by the government, height order dated so-and-so, was forwarded to the Commissioner, Guwahati Municipal Corporation, being the requiring department, and the same has already been deposited by GMC. Government approved the award statement of LA case number so-and-so, height so-and-so dated 8/11/2012. The notice under section 9(1) of the LA was issued to the concerned Kottadar sellers for receiving land compensation. Accordingly, almost 95% land compensation has already been released to the concerned Kottadar tenants.
You have to, they have received it.
No, no.
Are you a part of this LA case number 3 of 86?
Yes.
You have not received.
It is calculated there. They have.
Where?
Amount is ready, but if you have the pendant certificate,
Lordship may be
there is
pleased to
pension
come.
certificate.
Lordship may be pleased to come to the next, my lord, case.
Okay.
That is, I have just now read, my lord, paragraph 16, subparagraph 1. Now,
Wait,
paragraph,
I am coming in 5 minutes.
my lord. My lord, subparagraph 2. The land measuring 7 bigha 14 lassa has already been acquired by LA case number 3 of 86, part 1A for construction of Adabari Bus Stand Park in village so-and-so. Accordingly, government approved notification so-and-so dated 6/8/2011. Again, government approved the declaration under section 6(1). The land valuation of the acquired land was fixed on so-and-so, and accordingly, land estimate amounting to rupees so-and-so approved by the government and forwarded to the municipal corporation, being the requiring department. And the same has already been deposited by GMC. Government approved the award statement of LA case number so-and-so by the notice under section 9 was also issued. the payment of land compensation has been kept on hold as Joynath Sharma and others filed a writ petition before this honorable court, being WPC number 2330 of 2010. Now,
Stay.
2330 of 2010 is, my lord, item number 17. Now, Lordship may kindly, my lord, that affidavit, Lordship may kindly come to page 247. Annexer B. That is the declaration by the department. Down below, my lord, at page 247, my lord, Lordship will find, my lord, down below, the declaration is made under the provisions of section 6 of the Act of 1894. Then the very next page, my lord, is the communication, my lord, from the
But there is no stay to not to pay.
Look, there is no state to not to
Then
pay.
why haven't you paid?
Look, because,
Have you deposited it in the before the reference form?
look, now, my lord, what my submission
No,
is that
that the question will be after interest.
the difference is that, but my lord, my submission is that, my lord, admittedly, my, if you go by this affidavit, already, my lord, the acquisition process is complete and an award has been passed. Now it is with regard to, my lord, disbursement of the awarded amount. This is the issue beside. Whatever
Where does
submission,
the section 9 come into?
my lord,
How does section 9 come into the play? What is section 9?
9 of the 1894 Act.
What does it say? As far as I remember, section 9 pertains to you are going to give notice to those persons concerned asking as to what is the amount of value you want.
Yes.
That's all.
That's all.
Then how do you bring in section 9 passing an award prior to section 9? How is
Because,
it possible? It means section 9 has not been adhered to.
yes, perhaps, my lord.
Anyway, that will be a
Because
subject matter
yes,
of consideration for the execution. How much that
because
is the
section
contour.
9,
That is on the contour. So
section
the
9
petitioner here is could be at liberty to file separate application for that. As it has been done, the court has been rightly or wrong.
So what I understand from this entire bunch of writ petitions, that dispute is perhaps, my lord, with regard to apportion, there are rival claims between
Understood.
parties.
If there is a question,
Absolutely,
it court is-
absolutely, absolutely.
but the fact that the applicant has paid not paid, and with respect to the 7th third of that, paid, although there is no stake,
No,
and you are in a state.
Yes.
So section 34 will be applied for which first year, and it will be there. But the question of apportionment there, matter has to go, has to be taken by the decision.
then lordship may kindly see, my lord, the writ petition 2300 of 2010, because this affidavit speaks of, my lord, that due to pendency of this particular writ petition, my lord, the amount
No,
Yes.
it does, see, the pendency does not make any sense.
interim order. I have
There's
not
no, the
gone through that.
interim order is the status quo maintained at the time.
Perhaps, my lord, the authorities have understood in that way, my lord, that we cannot disperse the compensation. Maybe, my lord,
There is nothing of
that is my submission.
And in fact, from 2012 onwards, there is no interim. See, this order was immediately passed on 9/4/2010,
My lord,
making it returnable on 5/5/2010. Till returnable date, the status quo as regards the land question shall be maintained where the state and by authority.
my lord.
Then, the J. Henry Keller, the government advocate, representing the of a space for time is granted, certain up to date of the space for time. If the date of 9/4 with to the next date. Then the matter came up on 28th of 30th of the understand the payment of debt. So from 2013 onward, there was no debt.
Because this affidavit specifically says, my lord, that the payment of compensation has been
When an
made on.
affidavit is filed, I think people know what is the content of the
Yes.
restriction, what is the intent for the past. Let us see what is the order past, what is the restriction into the request.
Yes.
So this is the order of de-requisition. It is on the question of de-requisition. On the other hand, it doesn't have any validity in view of the fact that after that, things have been limited. So
No.
yes,
No, no. My lord will take up their affidavit
no,
once
that is
again.
what I am saying.
That, no, no, my
The
lord.
section 4 notification.
No,
was
my lord,
on
this notification, they have not read the notification in relation to our land. 247 is the land, my lord. 247 is the land, excluding our land is 258. Not, there is only section 4 notification. Not 258, my lord, relates to our land.
248.
258. 258.
Yes.
240, 258, my lord, kindly see. 258.
Yes, read it.
258 is, it is hereby notified within the boundaries described below, measuring 7 biga, this is our land, 14 Kasa, Gorpandu, so and so park. North 74, so and so, south, here also, and down below, my lord, only section 4 notification is made and section 5A is dispensed with. That is not section. In the earlier case, and in T47, Lordship will find declaration is made under section 6. Here, there is no declaration under section 6.
Where?
This 258, 258, there is no declaration under section 6.
Why you are saying so? They are saying that there is a declaration which is at page 271. 261 in your book.
261.
This is the declaration. And then the award has been passed. So if the award has been passed, this is the proceedings on the award which has been
And
passed.
my lord, if there is a order, or if there is an interim order in our case, in relation to this land,
yes.
how can they go ahead?
Huh?
How can they go ahead without section 4 notification even? How can they go beyond section 4 notification?
Why?
Because there is with regard to the status quo, there is already status quo.
That is only in respect to de-requisition proceedings.
With regard to land, my lord.
There is no stay to the acquisition proceedings.
No, de-requisition status quo with regard to the land in question.
Understood, but is it mentioned out there that the status quo as regards the land would be as regards the possession of the land?
Possession of the land.
Possession, they are in possession.
But no, after the de-requisition, possession automatically goes. There is the decision, bro. After the order of de-requisition is passed, there is no question of possession. Possession automatically restores to us. There is decision of the Supreme Court, our High Court.
Show me that.
In Lordship, kindly have a look at that.
No, be that as it may, you have not challenged this acquisition proceeding.
No, I have not, my lord, because I have no, I have challenged that.
You have not challenged
Where
this.
section 4 notification I have challenged. Section 4 notification. In the read petition final one.
Which one?
This 2872
of
2013. And in this case, the interim order is passed. I have annexed the notification at the last page, my lord.
Item 18.
Item 18.
Item 18.
Notification is page 120. Type copy 119. And here the interim order is passed.
Where?
In this case, my lord,
Where is the interim order?
in this case, there is an interim order, my lord.
No interim. No interim.
No, there is an order that order passed in, I think there, my lord. Or maybe I'm not sure whether it was.
Only that interim order of 2010 matter was extended.
Extended.
Nothing else.
That means there is an order in this case. No? If
So there is
in
no-
this case,
There
there
is no
order.
stay to the acquisition proceedings.
There is no.
So under such circumstances, if there is no stay, the acquisition has already come to an end by an award. And how can you challenge an acquisition proceeding?
How can they jump the derequisition? My lord? The derequisition is there. There is an order.
Understood. A derequisition may be illegal, whatever may be. Let us assume that the derequisition is illegal. Then what
No,
is the consequence?
derequisition, cancellation of derequisition.
Understood that the cancellation of derequisition is illegal. Let us assume that. Yes, it is illegal. But as on day, a section 4 notification has come, section 6, an award has been passed. So the only thing left with you is this.
Section 3 notification came, I came to know about the section 6 only now, my lord. The section 3 notification,
You
they
have
have,
not read the
for the,
file.
in our case, they have not filed an affidavit. Our case, they have not filed any affidavit.
Mr. Roy.
Any amendment made in our case is not,
Mr. Roy.
they have not filed, my lord.
What is your ground in this petition? There is no urgency.
There is no urgency, and my lord, when
But,
after
my
the
lord, in that matter also, one affidavit has been filed, my lord, by respondent number 5, WPC 2300 of 2010.
continue.
Mr. Roy, you should have challenged it on the
No,
ground that
Lordship.
5A has not.
Lordship will kindly come
There
to
is no
page
urgency.
68 of this petition, the last one. The Lordship will see the part first. Suddenly they cannot do this. Lordship, page 68, annexure 8.
Hmm.
May I read it, my lord? Just.
Yeah, what is it?
Seen acquisition proposal prepared by the Land Acquisition Mandal in pursuance to letter dated Penso Commissioner Guwahati 2005 for acquiring the land of 52 viga, 1 katha, 8 lesser, Kumarpara, for construction of park instead of bus terminus. So originally it was bus terminus. Now they suddenly say instead of bus terminus, it is park. Public purpose, how can it change, and requisition is always temporary. Requisition cannot be made.
Understood, but requisition is gone.
Gone.
Only
Now, that is why.
an acquisition.
No,
The
Lordship will
acquisition
see
has
the-
not been challenged.
This is Supreme Court has held, my lord, this is if requisition goes on and suddenly they say accusation, this is merely fraud and power. This is what the Supreme Court has held. my
Show
lord.
me that this is very relevant, not for your purpose, but other case.
Lordship will kindly have the position from the Supreme Court.
Because I am only. I'm saying
Well,
that
I know, my lord.
this continuous requisition with one TMC pattern with
No, no.
My lord, in that BPC 2300, that
Okay,
affidavit has been filed. The 2300 that relief sought for, my lord, is that, my lord.
I've seen it.
Yes, to restore the possession. Now, kindly, my lord, this affidavit filed by the deputy commissioner says, however, the deponent begs to state that the Adabari parcel under DMC exists on the requisition land of 59 acres, 2 kotha 10 acres, including land measuring 7 acres, 14 acres covered by
94.
tag number 146. They are seeking exploration of this land, which has already been
Paragraph.
proposed for acquisition for Adabari parcel. So it's not against LA case number 3 of 86.
Okay.
So it is already a part of, my lord, that LA case 3 of 86.
Where? Paragraph
My lord, paragraph 18.
para 18.
Paragraph 18. Prior to that, lordship may also peruse paragraph 16.
However, the deponent begs to state that Adabari Bastan was under GMT. Exists
My
for
lord,
requisition land of 59 acres, including current. They have already been put by.
against it. Now, to this affidavit, my lord, there is no reply affidavit.
Yes, let us see the judgment. If it-
My lord, paragraph 6 at page 340. I'll read it, Lord. Para 6. But it was contended on behalf of the appellant that even if the order of requisition was invalid, as having been made for the purpose other than the public purpose, the respondent number 3 was not entitled to challenge the same after a lapse of 30 years, and the writ petition should therefore have been dismissed by the High Court. Now, if only ground on which the order of requisition was challenged in the writ petition was that it was not made for public purpose and was therefore void, perhaps it might have been possible for successfully repel this ground of challenge by raising an objection that the High Court should not have entertained the writ petition transfer. But we find that there is also another ground of challenge urged on behalf of the respondent, number 3, and that is very formidable ground to which there is no answer. The argument urged under this ground of challenge was that an order of requisition is by its very nature temporary in character, and it cannot endure for an indefinite period of time. And the order of requisition in the present case, therefore, ceased to be valid after expiration of the reasonable period of time, and that it could not, under the circumstances, continue for a period of about 30 years, and hence it was liable to be quashed and set aside. And in any event, the state government was bound to revoke the same to re-requisition the flat. The contention has, in our opinion, great force and must be sustained. There is basic fundamental distinction between the recognition, requisition and acquisition. The Constitution itself, entry 42 and list 3 of the 7th schedule makes it a
Yes, Mr. Bortugari, I've got that for that other thing. See, we do not think that the government can, under the guise of which it continue for an indefinite period of time, often acquire the property, because that would be a fraud on the power conferred in the government. That is what the Supreme Court meant.
that is right.
The Supreme Court meant that in the form of requisition, which the state government has been doing in respect to the GMC land, you cannot continue in this manner for, in fact, if you continue indefinitely, the difference between acquisition and requisition
Will go.
becomes blurred.
Lordship is right.
So that is it.
No, my lord, my
And therefore,
submission
it
here
says,
was just
if
for
the
one
government
moment.
wants to take over the property for an indefinite period of time, the government must acquire the property,
At the
which have-
beginning,
which have been done here.
they have not.
In that, they have acquired.
No, my lord. If their purpose is to construct a vast and terminus,
Mr.
it is
Roy,
very nature permanent.
Mr. Roy,
It is very nature permanent.
Mr. Roy.
Well, that decision.
These acquisition acts which are there provides, therefore I say, the filing of the writ petition, that is of the 2013, is not on a proper edifice. Why I'm saying is this. When a notification is issued under 2011, in 2011, under section 4, thereby taking away the right under 5A, your pointed challenge ought to have been
On 5A.
on
5A,
5A,
right.
because 5A
Takes away my
gives,
right.
gives you a right to challenge that the acquisition is not made in public purpose.
That's right.
But your entire edifice of the writ petition is
No,
on another
We,
aspect.
we did it. We did it because the 2013 only the first time the notification 4 came. We have
And,
we have
and
challenged that.
2013, by the time you have come, the award has already been passed.
My lord, we came in 2007.
Those are
That's
different.
Therefore, this is a continued process. There is a continued process. 2007 we challenged, and when 2004,
That Supreme Court decision, Lordship,
and
hammered it upon us tomorrow. And Madhu's Chaudhary case is coming up tomorrow.
Because I know this is the thing, but I was not getting a judgment to impose upon the state.
Countering that one.
So that is the main problem which is happening. Your case, what has happened? The main problem, Mr. Roy, with due respect, you have filed writ petitions from one after another out there, but the main problem is you have not challenged the acquisition at the right point of time. You have challenged in the year 2013 in respect to an acquisition which is already complete.
no, that is not complete.
Yes.
2000
No, the award was passed in 2012. That is what I'm saying. You are challenging a notification under section 4 at a time when the award has been passed in 2012. Matter ends there. So the only thing is, you are therefore to take up the matter with under the reference for the acquisition, whatever is required to be done, as regards to making a reference for
that there I'll
enhancement.
not get back my land.
Because that is why I'm saying your edifice was wrong.
That is only regarding the compensation and all, my lord.
No, therefore,
No,
there
there
is in fact one judgment.
My difficulty is, my lord, that after the de-requisition order, I applied for permission to sell that. The government permitted me. I sold it, and the petitioners are here. The purchaser are here.
Understood. So the money now will be received by that purchase.
They are not in possession. But in fact,
You don't
they
require
have to-
possession.
what
Your right has been taken away, so you have to get the money back. Now, the only thing which made a mistake, there is no interim order by which, or they will put up a stay of the acquisition proceeding. In fact, at the time in 2010, when the order was passed, a status quo was granted as regards the land,
There's possession of them.
as regards the possession of the land, because you were saying that possession will be disturbed, they will do whatever may be. Now, once the possession has been taken away, the possession was all along with them.
No, after the de-requisition, it was not that
All may
Legally.
not be
legally.
legal, but it was all along with them. And I think you should not submit that as of now.
No,
No, if you say that, it will hamper your case for your interest. Better don't make that submission that the possession.
then I will not get compensation. The lordship is indicating. If I am
No,
not in
you
possession, I
would
will
not
not
get the interest. The interest which is there would be only from the date of possession.
That's right. I understand. My grievance was with regard to, my lord, the right towards my land. The land belonged to me, and the land, even despite the requisition, they are only licensee, my lord. They took our possession, and that should be for a temporary purpose. It cannot be for the purpose of.
All understood. But that was a stage at 5A.
No,
And
no.
therefore your edifice of your repetition is wrong. That you have challenged under section 4 without saying that yes, they have wrongfully or it is an abuse or it's a fraud on the power which has been conferred
But
by not taking into account, by removing 5A.
now that we have perhaps, that is the
No.
repetition. We have challenged that.
Your judgment is there was an order being passed, of an interim order being passed. That is not your case under 5A. In fact, you had the opportunity. You could have very well said, but you have not challenged that. There is a very beautiful
And my
judgment
lord,
of Justice China, I
the-
think, Justice
Your
Ivan
and
Reddy, when he was there in
Because you
Madhya
are
High Court, the full bench judgment. You will say, in a land acquisition proceedings under 1894, you can challenge a proceeding on 3 grounds. One is non-compliance to Section 4. Second, non-compliance to Section 6, and more particularly the limitation. Number 3 is Section 11, and more particularly 11A. If you don't come within it, the others come within the ambit of compensation. That is the basic.
my lord, 1964 Act provides under Section 6. Lordship is aware, but Section 4 is requisition. They have not taken resort to Section 6.
So,
It says
Now,
if
are you saying
No, no.
are you saying that section,
procedure, Section 4, LA Act will provide the procedure will be followed.
No, this is done under
But-
1894 Act.
no,
No.
I understand, Mr. Roy sir. Roy sir is saying is, you have initiated proceedings under Section 3 of the 64 Act for acquisition. And you could have done under Section 6 or 9 of the for acquisition.
Yes,
But you have not done. What
Yes.
you have done is you have gone under the 1894 Act.
1894.
But what is the problem?
Here it said may acquire by a gazette notification has to be under this act therefore. By a gazette notification,
Understood. Whatever may be. But does it say that it cannot be resorted to under the Land Acquisition Act? Anyway, good news, 2007 matters that
No, because
Yes.
they were lucky, my lord. The provisions, my lord, unlike 5A, is not incorporated in 64 Act. There is no scope for any objection. They had been given a scope.
no, you have not given the,
No, my lord, we have gone under 1894 Act.
there you have invoked the urgency on the 17-4.
Right.
Ah,
Then, my lord,
and thereby, that is what I have been telling Mr. Roy. His edifice of his case should have
I
been
understand.
17-4 could not have been invoked out here because there is no public purpose. And the only objection which is there in a proceedings out there is as to whether it is in public purpose. KV. Yes, Mr. Hearing complete testimony. But you make the, when are you making the payment? There's no stay business out here. No stay. On one hand, you are saying that the pendency of a repetition in 2010, you are saying because of that, you have not made the payment to them. On the other hand, pendency of the matter and there being an interim order did not stop you from requisitioning. What is this?
95% of the
No, not about 90%. I'm not on 95%. I am on the question of the 7 bighas of land, 7 bighas, 14 lectures of land, which is the subject matter of this petition. Why haven't you paid that? There's no stay to that effect. Then, now you understand the problem which is going to face. You are in possession. Are you in possession? Yeah. In possession. If they are in possession out there, 34 will apply. 9% interest and 15 for last 10 years. You know what it is. It will be a huge amount. It has now, whatever amount has been, it has now tripled. More than that. 15%. It's a valuable land. Let it be.
It has been handed over to the DFC. DFC local bank.
do whatever makes. But the requiring authority, they may have to file application. You file an application, I'll direct the DC to immediately, within 30 days to refer it to the district judge. This is the only way. And if you have any problem as regards apportionment, all these things will be. Now he is challenging tail deeds in a way where
Compensation matter.
compensation go there.
Because of the other. Not particular. Because the requisition order has been already called, that it is forced to.
No, that's right. They have changed the stand, my lord. Initially the two. When I've shown that
De-requisition aspect is the de-requisition is a long gone. If you have any money, apply for them. If you have been entitled to that, pay them. Whatever that direct.
His anxiety is that, my lord, he is the constituted authority of central function.
No, I know. That is why I asked him the name. This is what it is.
night.
Okay, Mr. Mahanta.
Sir.
I think the best option would be directing you, whoever it is, submit your application for the purpose of payment, whatever you offer during this period, till it is not done. Now, in the case, they are not in a position to decide, then stop.
Let, before that, may I have a little submission? Lord, after your lordship's observation, asking me to ponder, I have pondered. And I'm grateful that the course that is to be followed, or the anxiety we have, lordship has shown, regarding public exchequer, that has been taken care of by the lordship. Therefore, here, well, firstly, kindly see, this was a process of tender initiated for a period of 7 years. 7 years will come into an end after 4 years hence. So while fixing the rates, the authority was aware about, and it was in their mind that this fixation of the value would be for a period of 7 years. And the whole period must cover so that the public interest doesn't suffer. Therefore, while issuing the tender, they fixed a price. And they wanted that someone to bid above that, and a valid highest bidder should be settled. Now, that yearly value that was the bid offered by the respective, in case of say me and the respondent, it is more than the double, and every year 10% increase. So till the 7th year comes to an end, that 10% increase will continue. Therefore, the public exchequer's interest is taken care of by the authority, and if the settlement is made during this period, if any dispute arises, then the bid, which is found to be validly highest, will take care of. That's why my response submission is that it should be, if the settlement is asked to be made, considering the second valid highest bid, then it will not cause any injustice, or it will not result any damage to the public exchequer.
How much did you quote every year?
58 lakhs.
No, that is the total.
No? Yes.
How much did you quote? Because you must have applied 48.
Yes.
Rule 48, by which there is a 10% minimum 10%.
Yes,
increase.
that is taken care of here itself. 10% increase every year. That is there. Kindly see. Let here at page 118, lordship will see in their cooperative statement, and they've prepared a note there. Indian Imperial Order, they have quoted it at 118. Mrs. Mongoldoy Pioneers, the petitioner. The society offered rupees 4 crore, lots got it, Mal. Society offered rupees 4 crore 6 lakhs 3,500 for 7 years. That is at the rate of 58 lakhs 500 per annum, which is the second highest bid.
So your bid should be cancelled. It is not in consonance with 48.3.
No, Malad, 10% increase will go ahead.
Now, how do we know that it is a, here it is said per annum?
No, Malad, per annum, that is every annum.
Every annum there has to be a 10% increase.
Then next, from the next
But it
year.
is every month, every
From-
year.
Every year, next year,
So multiply it, 58
Multiply
lakhs,
it.
50,000 into 7. What is the amount?
it will at the rate of 58 lakhs per annum, and it will include 10% every year. That is the condition. It will be an added amount to this. It will be an added amount. 10% will be added.
No, there is no 10% increase. Your bid should have been cancelled.
Malo,
under
that
48.
that would be an added, because
No, Mr.
kindly see, my lord.
Mr. Mondo, kindly multiply 58 lakh 500 into
Yes.
7. The amount comes to 4 crores 6 lakh 3,500. So
Malad-
you have not quoted as per 48.3.
My lord, that is.
So your tender should have been rejected. Now should I interfere? Should I at all interfere on the ground that your tender was not the,
No,
At
my lord,
the-
that was not the
at
ground
the
on which.
behest of an illegible tender? Should I interfere now?
No, Lord, because that is not the, no, my lord, that
Huh?
is not the ground.
Yes,
That
no,
is
not
the
ground,
ground
but,
on which
but,
the authority
but
acted.
if you are submitting on that, I have
No,
to refer.
what I am submitting is that being the value and 10% every year. as
You have
per
not
law.
given. No, you have not given that.
No,
That
well,
is the
if
requirement.
not,
as
say
of-
that.
No,
Otherwise,
Mr. No,
10%
Mr. Monto,
Let the authority say.
that is the requirement of 48.3.
Now, whether that requirement was waived in case of everyone or whether that will be applied by the authority, settling authority. And it will be
Don't
applicable to
worry.
everyone.
We'll put that, Mr. Sharma.
That is what I am saying, my lord, kindly see. That is applicable to everyone. If they have not applied, they have not applied to anybody. Karan, Lordship will kindly see here.
So
but
if they have not applied to everybody, the rule 48 have not been have given a go by, which is a statutory.
that cannot be,
So under such circumstances, that cannot be given a go by.
it cannot be. So it will apply, my lord. Obviously apply.
So it has no, and then your tender is wrong. All the tenders are wrong. So rightly set aside.
My lord, not wrong, my lord.
Okay. That is the order.
Kindly see, my lord.
Rest is for you to file a pitch.
My lord,
This is the order.
kindly see, my lord. Should I just have?
Tomorrow. I'll set aside all these things and that allowing him to submit representations to the authorities, that if the authorities is not in a position to complete the tender process within a particular period of time, then any any interim arrangement has to be taking note of the representation to submitted, and thereupon if there is some confusion, it cuts out the very still.
My lord, now representation will be by whom?
Everybody.
Everybody. So not confining to only the
discrimination.
leaders here. It will be open for everybody.
Government, you see, it goes for representation and then only.
No, my lord, my question is yes. That will be again made known to everybody that look during this interim period, if someone wants. Otherwise, it may not be confined only to. Others will say if it is open for us also. We didn't know it. That is why I am putting the
So
question.
then I say that
Or if
why
it
I am
is,
saying only the representation to be submitted by you, but you have approved. it.
yes, that is
Others
why.
have not.
That is why. Then in that case,
Submit
Lord
your
will make it
representation.
specific.
You submit your representation and the authorities get for others.
That to that extent, Lordship only can
So
be
then
treated.
let the authorities for other persons also. I have no problem. But the thing is, I don't want to.
particular,
No,
But
otherwise, my lord,
But
otherwise,
Mr. Nath can continue in this manner if they don't settle.
no, that will, the lordship will make it clear also. Because now
I
he,
will make it. I will make it very clear to the
Yes.
effect that this settlement which has been made is interfered with. In the meantime, now the respondent, the petitioners herein are granted or respondents, the private respondent herein is granted the liberty to submit representation. If the respondents want to go ahead with to do something during the interim period pending settlement, and it shall be done. And if it is a position not to sell, to come to a decision, it will be shut down till the final.
settlement. Obligement.
Because the state government is losing in view of this.
only interest is there.
Yes, only because the state government is losing because of the pendency for the last 4 years. Okay, I'll tell you the judge. Huh?
Well, in such matters, as I found out certain decisions, our court has been settling it for the rest of the term at least. That the highest bidder should continue.
Really, it's a good thing for you to file a dispute.
It will be
Well,
beneficial not only for
law-
the client, my lord, also for.
Law will definitely take its shape with the passage of time. That is always there. But
Because you see, why this court should not do it? Because there are many other questions. If we further go deep into this, there are many other questions. And would you be entitled for only 3 years or 7 years?
no, 7 years the term. And
So
now
you'd be
in this
at
case,
best be entitled to 3 years.
no, 4 years left. Even then, here, that 7 years has not started because no formal settlement was.
So therefore, you will be entitled to for 3 years only. If we take that value, you can't be entitled for more than that.
Even then,
Even
then,
otherwise also.
I concede to that 4 years left, 3 years gone. That period at least the highest bidder ought to have been, because that was in their mind that they have taken care of the bid value, that at least for this year, this will cover.
But there is no increase of 10% in your bid value. No.
Here, Lordship will kindly see,
All
Lordship will
other,
kindly see,
Mr. Mohanta, rest keep something for the division bench.
my lord, Lordship, I'm sure Lordship will consider it and lay down the law. Kindly see, here is a tender, there is nothing, no mention about it. That is why they
Not
didn't put that.
required. In fact, there is some case where somebody has tried out there saying that there is no mention about this applicable. I said whether rules categorically apply, say that it is 48.3, it is 48.2.
Two.
Categorically mentions that it has to be an
Enhancement.
annual increment by 10%. Then whether the tender pays or not, that is immaterial.
Well, that is why I am submitting, my lord. That is why I am submitting. I am bound by that. I am bound by that 10% will be increased. Increased.
At number 11 for the.
Apply.
May please, your lordship, I had a miscase that may be disposed of. For impeding lordship, I have filed in IA lordship 216 in this case. So that may be disposed of as because lordship is disposing of the main case. Much obliged.
Yes, what is this?
We have received instruction.
Ah.
Cost of transportation has already been paid from October 2000, March 2000. For
Order.
AAY,
तू order नहीं, ये तो order कौन है?
for period of July 2008 to October 2015 has already been paid. And then
You are asking for only this, huh?
yes, Lordship,
11 August 11 to March 2012.
that is pending. From
Remaining you have got it.
Suddenly September, September 2008, the transportation charges has not been released to the petitioner society.
Oh,
This is a
madam,
registered
how
society.
are you
Till today, Lord.
fixing up this 11
Till
lakh
today.
50,000?
They have.
Huh?
They have not.
Affidavit not filed with instruction in last order to bring instruction. Last order of the honorable court directed.
What do you want?
Kindly fix the date, Lordship.
For what?
Lordship, and kindly see the last order of the honorable court. There,
List the matter again on so and so on which
They
Ms.
have-
N. Gustami, the learned counsel,
They
shall
have to
obtain
file
instruction as
affidavit.
regards petitioner's entitlement.
Lordship, respondent has been directed to file affidavit in the last order.
I'm not asking.
No, but-
I'm only asking them to get the instruction.
Oh, yes, Lordship.
They've got the instruction
Yes, sir. Kindly fix the date, Lordship. Kindly fix the date.
for what? Therefore, pursuant to the order passed by this court on 8/1/2024, Mr. S. Purva appearing on behalf of the respondent.
My
district
senior is
administrator
due this case, Lordship. Yes, Lordship. For
Yes.
government, Lordship.
for the respondent authority submitted an instruction to the effect that the transportation charges for AAY ride for the period from July 2008 to October 2015 have already been paid by the subdivisional officer C. Hakuakana by order dated 9/2017. In respect to MMASY ride, the transportation cost for the period from 2000 October 2010 to March 2011 have already been paid by the Deputy Commissioner Lakhimpur by sanction order dated 16/6/2015. However, as regards the transportation charges for MMASY for the period from August 2011 to March 2012, the same have already been issued by the government. However, the payment is under process. The learned counsel appearing on behalf of the respondent further submits that the state process would take some time and would be likely to be completed after the budget. Taking into account the above, this the matter again on 3rd of April 2024, on which date Mrs. S. Burwa shall update as to the present status of the entitlement of the petition. The instructions so placed before this court and kept on record and marked with the letter Y.
Okay.
Yes, why the matter has come?
My lord, this is analogous matter that was listed on 19, my lord, WPC 5354 2018. My lord, the issue is relating to, my lord, claiming of the financial support, my lord, from the government regarding, my lord, construction of an additional classroom under the, my lord, the MSDP project. So, my lord, the
We'll have it for taking into account the additional the application for Dusty. You have filed an application, the affidavit for Dusty.
that was, my lord, the service was complete, I think.
The private respondent has already filed the affidavit.
So they are there.
They have filed it, yes, every filed it.
This is the matter of Vivekananda.
Yes,
Yes.
Okay, list the matter for admission. 28th of February 2020.
my lord, I pray, my lord, that to be listed along with, my lord, this WPC 5354 2018, this is disposed of now.
Why?
Because, my lord, here the respondent number 10, he was the petitioner in that case.
Along with deputy.
WPC number 5354 2018, disposed of 19-1.
Not before me. We'll sit before you. We will.
Item number 19. 19.
Lordship,
Yeah.
engaged counsel Mr. Ekeda left the court.
Huh?
His maternal uncle expired yesterday to attend a funeral ritual. He went to Sasan.
Item number 19.
Maybe
Has
list
been
two more.
informed that the part that the learned counsel appearing on behalf of the petitioner, Mr. Arkedas, has to
Ekedas,
leave the court
Ekeda.
on
Ekeda.
Arkedas.
Ekeda.
Where is Ekedas? There's no Ekedas here.
Ekedas letter.
Ekeda.
Huh?
Unknown.
There's no Ekedas or Ekedas. What
Ekedas.
about the other people?
Now only Ekeda is appearing.
What?
I
You are also there.
I'm also there.
Very well. Very well. Yes. Now, yes, so many advocates. Yes, what is the, oh, I have fixed it. On hearing the learner the question, which arises for consideration as regards the veracity of the documents which have been enclosed as an exit E series to the receipt of the staff pertaining to shall instruct the official of the the state thereof shall apprise it that have a reason out of that number in. Yes, what is case control
Lordship.
is the name.
Yogesh Chandra Pal.
His name is there.
In Lordship, my Lord, 121, my Lord, earlier.
Huh?
And 203. Old and new, my Lord, tag number.
203 and 486. 1 bigha 2 katha 12 hectare. And Patta is 238. What is the why the matter has come up to this?
Lordship.
This is Patta number 238. And what was the earlier Patta number? Four eight six is that is the entire land.
Lordship.
Now, as of now, the land is in the name of Yogesh Chandra Paul.
My Lord, Yogesh Chandra Pal.
Huh?
My Lord, as per my Lord, they already been received some amount. My Lord, they have, my Lord, file additional affidavit. That one where they have stated that this tag number.
So, Yogesh Chandra Paul's name, this is the kita.
Lordship.
ইমান নম্বৰ ডাগৰ লিখা হুকুম নতুন ম্যাদী ভুক্ত হয়। This is of 1962.
Lordship.
Now, what is the present status?
So, my Lord, that as per our instruction, they have been paid. My Lord, they say they will not, they did not receive the amount or my Lord, that.
I don't know the metric.
Lordship, in the next case, Lordship, my lord, Omullo Das, my lord, there have been, my lord, two brothers of this, my lord, that have been filed, my lord, that petition. My lord, he has then withdrawn, my lord, only because of that, my lord, they already received the share, my lord, that amount.
So, but what about doc number 482 is not there?
482 is the one. My lord, subsequently, they have, my lord, claimed that, my lord, 482 is there, the doc number is there, my lord, they are the owner. So their compensation has not been paid to them.
So 482 they say they have enclosed out there.
In the additional affidavit, they have been filed.
That is also made Sarkar from Jugesh Chandra Pal. That is also this is 12 bigha, ekotha, 4 lecha. What about 482? There's no, yeah, 482.
No point.
What? Kota number is what? How did this, what do you say about the veracity of this document?
The additional affidavit, they have been filed. They have been, my lord, that annex in the annexer ACS, my lord, that which was, my lord, that doubtful, my lord. On that
Very
day, I was also point out of
Very difficult.
page 6, 7.
Ah, yes. What does he say?
Along the land, my lord, they have mentioned that 482 and 483.
Huh?
Down below, lord.
Page?
6, lord, in the additional affidavit.
Ah.
Schedule of the land, lord.
482 and 486.
Lord.
Yes. Then?
And Lord, my lord, kindly see the next page was 7, page 7. It was, my lord, that they haven't submitted this petition, my lord, on 16/1/1972. And my lord, they last, my lord, left hand
This
side, my
is
lord,
written by hand, I remember now.
Lord. That guy, Lordship, was asked me to the, my lord, obtain instruction, my lord, 482.
Only I asked you to obtain instruction. But what is the veracity of this annexure? That can be inquired or not. I'm not on the other aspect because you see, 480 this therefore this document at page annexure 1 series 486 seems to be in order. Page 26 of the writ petition. It is in order. As from the Chita.
Lord.
This is in order.
This is in order.
Order. But what about the other one? I have asked you to find out this one also. You have to give a comment. Whoever is certified this. This has been given in 2011. Must be new one.
Might be. Lord.
Then, pursuant to the order passed by this court on 4/1/2024, Mr. J. Hendrick, appearing on behalf of the District Administration, Kamrup Metro, have submitted that tag number that verification of the records in respect of tag number 486 was done. And it was found that tag number 486 has a written out of tag number 4. And accordingly have enclosed, have brought on record a copy of the Chita. From the said, it revealed that tag number 486 is the new tag, whereas the old tag was tag number 203. And the land included therein is 1 bigha 2 katha 12 lecha. And the concerned patta number was 38. It is also seen that the name of Dukesh Chandra Pal was mentioned as the pattara. So This, therefore, seems to be in consonance with the draft sheet enclosed to the writ petition at page 26. However, as regards DAG number 482, it has been mentioned that the records could not be traced out. Be that as it may, this court would like to know as regards the veracity of the said document. So, under such circumstances, this court fixes the matter again on 15th of March 2024, on which 14th of March 2024, on which date the learned counsel shall, Mr. J. Henry, shall apply for the instructions which have been placed is kept on record and marked with the letter X. Yes, any urgent matters? Yes,
Except item 21, perhaps my lord may not like
oh,
to
that
take.
I won't take. Take the back. 21.
Yes.
Hello.
Item number 21, the back.
Hello, item number 24.
Huh?
Item 24.
24,
24.
yes.
My lord, this matter may come up after my lord 14.
Why should
20,
I hear
23 and
you,
20.
Mr. Pukasta, your name does not appear anywhere.
23.
Huh?
23.
Now you have,
I'm sorry, ma'am.
23 is okay. Why you are going into 24?
23.
My lord, item number 24.
Yes, but
Maybe.
Huh?
Maybe.
why?
Here, also directed to have a joint expression 4. The Carpenter Autonomous Council and the APCCL authority along with the revenue of the inspection report is available from that report.
Oh, report.
Yes, report.
24.
Item 20.
What is it?
Specifically for the report, they have proper time.
Which court have taken note of the constructive dated 6,054 of the Secretary Department of Revenue from the Council. In terms of the state report, in terms of the state report, is that the preliminary report has been prepared and final report is made within a period of 7 days. Taking into account the above, it's the matter again of 7th of March 2024. By 4th of March 2024, the Party Club must certify the affidavit being on record the final.
For 5, 6 and 7, I will. For response number 5, 6 and 7, I will take.
My lord,
Being appearing for ATCLU.
Yes.
The Ika, the learned after the appearing. I submitted the APC shall take appropriate steps pursuant to the report.
hello, item number 24, any rate, 23, sorry,
23 again.
23. Sorry,
You got the
23.
yes. 23 why?
23, my lord, after 14.
Why?
My lord,
You
I have
like
some,
it?
yes, my lord, I have some
14th of February.
14th of February.
Why? After
My lord, in between, my lord, I have some personal problem.
yes, but it is
My lord, I pray that if it can be after 16, because 14, 15, 16, I have got a real matter, sir.
okay. At the request of the party, matters can be discussed.
Apply.